Item 1 and 2 of daily list, admission, part matter.
This matter also only the state has to give its reply, and I have to give a short rejoinder to the reply of the respondents on those. Private respondent, they have already completed their reply.
My respectful submission is that I have almost completed my arguments. And if there be any clarifications required, my lord, I won't take time, and after submission of my good friends, I may be given little, because if there be any clarification, they be offered.
My lord. Lord, with due respect, my lord, I represent the state of Manipur, my lord. My lord, these two writ appeals, my lord, arose against the common judgment and order dated 20 July 2022, passed by the Honorable Single Judge, my lord. Whereby, my lord, the writ petition number 724 of 2019 was allowed, and writ petition number 916 of 2019 was dismissed, my lord. The two writ petitions, my lord, were filed, my lord. One, to implement and execute the order of the state, my lord, that is dated 22nd January 2018, passed by the Secretary of the Corporation, my lord. The writ petition number 724, praying to execute and implement the order of the state. And the writ petition number 916 of 2019, to quash and set aside the order of the state, my lord. My lord, the impugn, my lord, the order, that is, my lord, 22 January 2018.
You are referring to which appeal?
My lord, I am referring to, my lord, that is 97, that will be writ appeal 28, my lord. The thin one, my lord, writ appeal. The other one is thick one.
Why can't you refer to 96?
My lord, I have gone through properly, my lord, one and the same, all the documents enclosed here with my lord. So I have referred all, my lord, exclusively, my lord, 97, my lord. That is 724, my lord. And some of the documents also I will refer to them, my lord. As these are the, my lord, all the orders and the judgment and order also common in the previous writ petitions. My lord, that will be at page number,
One
I
minute.
think page number 75.
1 minute.
Let's see there. My lord, running page number 75.
Of writ April 28. Writ April 28.
Yes.
Yes, yes.
Running page.
75. Because the two writ petitions arose from this order, my lord. So, my lord, may be pleased to allow me to read out this two-page order, because this will be very important, my lord. My lord, this order is issued by the Secretary Corporation, my lord. From the beginning, I may be allowed to read out, my lord. 22nd January 2018. Whereas certificate of registration of a society under the Manipur Societies Registration Act 1989, bearing number so and so, dated 12 November 2009, issued by Registrar of Society Manipur in respect of Manipur Hockey writ as under. It is hereby certified that Manipur Hockey, having its registered address at Imphal, has been registered under Section 7, Clause 1 of the Manipur Societies Registration Act 1989, bearing registration number so and so. Whereas the certificate of registration of an amalgamated society under the Manipur Societies Registration Act 1989, issued by Registrar of Societies Manipur on 21/1/2010 in respect of Hockey Manipur writ as under. It is hereby certified that pursuant to Section 12 of Manipur Societies Registration Act 1989, the society is hitherto called Manipur Women's Hockey Association registered number so and so of 1976, dated 23rd October 1976, and Manipur Hockey Association registration number so and so of 1976, dated 26 October 1976, have been amalgamated into one society in the name of Hockey Manipur, Humalampak, Imphal East, with reference to the proceedings of the joint general body meeting of the two associations held on 18 October 2009, registration number so and so, dated 21st January 2010, has been allotted to the society. Whereas Section 10 of the Manipur Societies Registration Act 1989 lays down as under. 10. Name of the society. No society shall be registered under a name which is identical with or too nearly resembles the name of any other society or anybody corporate which has been previously registered or incorporated under this act or an other law for the time being in force, as the case may be, or is deemed to have been registered under this act. And whereas Section 11 of the Manipur Societies Registration Act 1989 lays down as under. 11. State government may direct change of name. If a society is registered under a name or alter its name to another name which in the opinion of the state government is identical with or too nearly resembles the name of any other society or body corporate which have been previously registered or incorporated under this act or any other law for the time being in force, or being deemed to have been registered under this act continues to exist, the state government may by order met in this behalf direct such society to change its name and alter its memorandum within 3 months from the date of the order on such longer period as the state government may think fit to allow. 5. And whereas on perusal and examining the above two certificates minutely, it is fully convinced that when the following two societies call under the name and style Manipur Women's Hockey Association registration number so and so of 1976, dated 23rd October 1976, and Manipur Hockey Association registrar number so and so of 1976, dated the 26th October 1976, are already existing registered societies. Registration of a similar society under the name and style of Manipur Hockey on 12/11/2009 is a clear violation of Section 10 of the Manipur Societies Registration Act 1989. 6. Now, therefore, after due consideration of the aforesaid facts, I, Sri M. Joy Singh so and so, Government of Manipur, in exercise of the powers conferred upon me under Section 11 of Manipur Societies Registration Act and Rule 14, Sub-Rule 9 of Manipur Societies Regulation Rules 2004, do hereby direct Manipur Hockey to change its name and alter its memorandum within 3 months from the date of receipt of this order, my lord. My lord, this is the impugned order, my lord. My lord, the order, this order 22 January 2018, my lord, this order, my lord, has been issued in pursuance of the order passed by the Honorable Single Judge in writ petition number 562 of 2017. That is at page number 72, my lord. My lord, before filing these two writ petitions, my lord, 3 writ petitions were filed by the Manipur Hockey, my lord, my senior councils, my lord, association, and the 1 writ petition filed by the Hockey Manipur, my lord. Yes. My lord, the writ petition number 562 of 2017 at page number 72, the order dated was 19 December 2017, my lord. This is filed by Manipur Hockey, my lord, the appellant. My lord, this writ petition has been filed to challenge the summons of the state, whereby if there is reconciliation can be brought, my lord, between the parties, my lord. My lord, at page number 74, that is internal page number 3, para number 2. On perusal of the said representation dated 27/6/2017, it appears that it has been submitted purportedly under the provisions of Section 11 of the Act, which has nothing to do with the cancellation, but to change the name of a society. Moreover, the summons dated 1/7/2017 appears to have been issued on the basis of the said representation, and therefore the same is not sustainable in law. In view of the above, the instant writ petition is allowed, and consequently the said summons dated 1/7/2017 is quashed and set aside. However, it is open to the state government to proceed in accordance with law as regards the registration of a society pertaining to hockey sports in Manipur, keeping in mind all circumstances and in particular the fact that the petitioner society is an affiliated unit of MOA as per its report dated 12/8/2017. My lord, the state passed the order, my lord. As per the honorable court's order, my lord, it is open to the state government to proceed in accordance with law as regards to the registration of the society, my lord. My lord, coming to the, my lord, judgment of the, I would like to refer some paragraphs which are important, my lord, to the judgment of the honorable single judge. My lord, yes, passed on 20 July 2022, my lord. This will be found at, my lord, the relevant paragraphs, my lord. I have noted down also, my lord. Page number 27, my lord. Page number 27, my lord. Yes, 27 for my lord. My lord, WPC number 724 of 2019 has been filed to issue a writ of mandamus directing the respondent number 1 and 2 to implement and execute the order dated so and so issued by the Secretary Government of Manipur and letter dated 14/1/2019. Yes, my lord. May I read out, my lord?
Yes.
Yes. And letter dated 14/1/2019 issued by the Registrar of Society Manipur, my lord. WPC number 916 of 2019 has been filed to issue a writ of certiorari mandamus for quashing the order dated 22/1/2018, directing the petitioner therein to change his name and alter its memorandum within 3 months and to direct the respondents 1 and 2 to consider and dispose of the representation dated 29/12/2017. My lord, paragraph number 6.2, my lord. The case of Hockey Manipur is as follows, my lord, paragraph 6.2 at page number 27. Uh, 27/6, my lord. The ad hoc committee was under the presumption, my lord. May I read out, my lord? Continue.
Yes.
Yes. The ad hoc committee was under the presumption that Hockey Manipur was converted into Manipur Hockey upon its registration with Registrar Society is Manipur, bearing registration number so and so. Manipur Hockey was formed on 6/10/2009 without holding a general body meeting, and it has not fulfilled the required procedure and proper documents. Thus, Manipur Hockey was registered on 12 November 2009 by some vested interested persons with malafide and ulterior motive, and the same has been done while the process for amalgamation of Manipur Hockey Association and Manipur Women's Hockey Association was pending. My lord, this Manipur Hockey Association, Manipur Women's Hockey Association, they were registered in 1976, my lord. I will come to the history, my lord, at the relevant time, my lord. My lord, 6.4 paragraph at page number 27. Challenging the process which are agreed, Hockey Manipur filed WPC number 435 of 2010 before this court, and by an order dated 17/3/2016, this court directed the Commissioner Cooperation Government of Manipur to dispose of the representation dated 4/1/2010 within a period of 2 months. Pursuant to the order dated 73/2016, the Principal Secretary Cooperation issued an order dated 2/8/2016 directing Manipur Hockey and Hockey Manipur to reconcile and come under a common banner within 6 months. Accordingly, on 1/7/2017, the Deputy Secretary Cooperation issued summons to Manipur Hockey to appear on so and so. Challenging the summons, the Manipur Hockey filed WPC number 562 of 2017 before this court, and by an order dated 19/12/2017, the said writ petition was allowed, thereby quashing the summons dated 1/7/2017, which I read before, my lord, the order, relevant order. My lord, at paragraph number 6.5 next. On 22nd January 2018, the Secretary Cooperation Government of Manipur passed an order directing Manipur Hockey to change its name and alter its memorandum within 3 months from the date of receipt of the order. Agreed by the said order, Manipur Hockey filed WPC number 124 of 2018 before this court, and by the order dated 27/11/2018, this court, in order to find out an amicable solution, directed the Registrar of Societies to examine and explore an amicable solution for having one association only for which Manipur Hockey was directed to appear before the registrar. Accordingly, on 14/1/2019, the registrar of society passed an order declaring that Manipur Hockey has violated the norms of registration and hence it is illegal. On 30/8/2019, WPC number 124 of 2018 was dismissed on the ground that the writ petition has no substance for the reason of non-joinder of necessary parties. Accordingly, Hockey Manipur filed WPC number 724 of 2019 for implementation of the order dated 22/1/2018 and the letter dated 14/1/2019. My lord, next page, paragraph 7.1, my lord. After formation of Manipur Hockey, it approached Hockey India, which is the apex body of the game in the country, for its affiliation with them. Thereafter, after taking into account the credentials of the members of Manipur Hockey who are managing the affairs of hockey in the state of Manipur, granted affiliation of Manipur Hockey to Hockey India with effect from 22/10/2009 of the President of Hockey India. In the said letter, Manipur Hockey was also requested to get itself registered under the Societies Registration Act within 6 months and deposit the required affiliation fee within 3 months from the date of the said order. My lord, 7.2, my lord. In terms of the resolution taken in the meeting held on 6/10/2009, necessary applications, documents, and registration fees required under the provision of Manipur Societies Registration Act and rules were submitted to the Registrar of Cooperative Societies for registration of Manipur Hockey. After completing all formalities and procedure provided by law, the registrar had issued a notification bearing so and so, my lord. Under Section 7(1) of the Manipur Societies Registration Act, after the registration, Manipur Hockey has been controlling, managing so and so, my lord. This, after then, my lord, on 12 November 2009, the Manipur Hockey was registered under the Manipur Societies Registration Act. And paragraph number, my lord, 7.7, that is at page number 27/13, my lord. 7.7. My lord, aggrieved by the order dated 22/5/2017, Manipur Hockey filed WPC number 391 of 2017 for quashing of the said order. During pendency of the said writ petition, the Principal Secretary issued an order dated 14/6/2017, withdrawing the order dated 22/5/2017. This, my lord, this 22/5/2017 is the order cancelled by the state government of the Manipur Hockey, my lord, without giving notice, and the writ petition was filed before the Honorable Court 391 of 2017. And after that, my lord, during that pendency, the same order cancelling the Manipur Hockey was withdrawn by the state. Just after withdrawal order dated 14/6/2017, Hockey Manipur again for the third time filed another representation dated 27/6/2017 to the Principal Secretary, praying for cancellation of the registration of Manipur Hockey. When the Deputy Secretary issued summons dated 1/7/2017, challenging the summons, Manipur Hockey filed WPC number 562 of 2017, and by an order dated 19/12/2017, the said petition was allowed. After the disposal of the said petition, Manipur Hockey filed an application dated 29/12/2017 to the concerned authorities of the state, requesting them for directing Hockey Manipur to change its name by invoking Section 11, as its name is exactly similar to the name already registered Society of the Manipur. My lord, yes, Manipur Hockey. My lord, this application dated 29/12/2017. My lord, in the writ petition 916 of 2000, my lord, filed by the Manipur Hockey, there is a prayer, my lord, to dispose of this representation 29/12/2017, and at the same time prayer to, my lord, quash and set aside the order of the 22nd January 2018 passed by the Secretary, my lord. That has been dismissed by the Honorable Single Judge in the present impugned judgment, my lord. My lord, their prayer and in the pleading also, my lord, they are asking to change the name of the altered memorandum of the Hockey Manipur in that petition number 916 of 2018, my lord, 2017. My lord, next paragraph, 7.8, my lord. 27/14 page number. According to Manipur Hockey, they are the only body affiliated and recognized by the Hockey India and MOF for the sports of hockey in the state of Manipur. Manipur Olympic Association, my lord, MOA, which had conducted many tournaments, coaching camp in different levels in the state of Manipur. Instead of considering the application dated so and so after a delay of more than 8 years from the date of registration, the first respondent issued an order dated 22/1/2018, whereby Manipur Hockey was directed to change its name so and so, my lord. There were already named within 3 months on the ground that at the time when Manipur Hockey was registered on 12 November 2009, there were already 2 associations existing, which is alleged to be a clear violation of Section 10 of the Act, my lord. My lord, page number 27/22, my lord, paragraph number 24. This is the observation and the, my lord, the views given by the learned, honorable single judge. My lord, to analyze the libel submissions of the parties, it would be appropriate to refer to the earlier litigation filed by the parties and the consequential proceedings issued by the official respondents, my lord. Before amalgamation of Manipur Hockey Association, Manipur Women's Hockey Association as Hockey Manipur, the president of Manipur Women's Hockey Association has filed an appeal before the Commissioner Register of Societies challenging the registration of Manipur Hockey dated 12/11/2009. During the pendency of the said appeal, the Registrar of Societies allowed the registration of the amalgamated society called Hockey Manipur by allotting registration number so and so, and had also issued an order on 21st January 2010 cancelling the registration number allotted to the erstwhile Manipur Hockey Association and Manipur Women's Hockey Association, my lord. My lord, next paragraph 27, my next page. It appears that during the pendency of WPC number 435 of 2010, filed by the Hockey Manipur, my lord, the General Secretary of Hockey India addressed a letter to the Director of Youth and Affairs and Sports, Government of Manipur, informing that Manipur Hockey is the only recognized body of Hockey India in Manipur state. My lord, paragraph number 32, my lord. (27/26) page number. Paragraph 32. My lord, by the page 27/26, by the final order dated 19/12/2017, passed in WPC number 562 of 2017, came to be allowed and the summons dated was passed. However, the court observed that it is open to the state government to proceed in accordance with law as regards the registration of a society pertaining to sports in Manipur. The order dated 19/12/2017 extracted hereunder, my lord, which I also read, my lord. It is open to the state government to proceed in accordance with law as regards the registration of a society pertaining to hockey sports in Manipur, keeping in mind all circumstances. The order has been reproduced here in my lord. I need not refer again, my lord. My lord, while passing the judgment and order of the Honorable Single Judge, my lord, at page number 27/39, paragraph number 43, my lord, as per the direction of the Honorable Court, my lord, as could be seen from the material produced by the parties, my lord, the Honorable Court directed the state, my lord, to produce all the relevant records pertaining to the order passed on 22nd January 2019, as well as the, my lord, the registration of the 2 societies. I produced, my lord, all 4 records, my lord, pertaining to the documents, my lord, before the Honorable Courts, and the liberty were given to both the parties to inspect and go through the documents, my lord. And after perusing all the records, the Honorable Single Judge passed this judgment and order, my lord. My lord, as could be seen from the material produced by the parties, in terms of letter dated 1/6/2009 of the Indian Olympic Association, The Manipur Olympic Association by its letter dated 27/6/2009 invited the President Manipur Hockey Association and Manipur Women's Hockey Association for a joint meeting for the formation of a single association. Both the associations agreed for merger, and after completion of all formalities, they stood amalgamated into a single society. While following the lengthy process and taking advantage of the situation, with the connivance of the President Manipur Olympic Association, an ad hoc committee was constituted which got Manipur Hockey registered as a society, which was recognized even before its registration. The Manipur Hockey, which was registered on 12 November 2009. Hockey Manipur, which was amalgamated on 21st January 2010. Just a gap of 2 months. As stated supra, continuation, my lord. Pending amalgamation of the aforesaid two associations, Manipur Hockey got registered, which is not the idea of the Indian Olympic Association. In fact, the Manipur Olympic Association informed the two associations for formation of a single association, and the ad hoc committee has no right to form Manipur Hockey and got registered. Since Manipur Hockey Association and Manipur Women's Hockey Association are very old registered association, that is of 1976, and decided to be amalgamated as Hockey Manipur, and the process started for it during June 2009 itself. The formation of Manipur Hockey is nothing but an association formed by violating the procedure laid down under the Act of 1989 and the rules of 2004 and obtain registration certificate. In fact, the Manipur Hockey registered under Section 7, Clause 1 of the Act, whereas Hockey Manipur is an amalgamated society registered under Section 12 of the Act. For ready reference, my lord, Section 7 and 12 of the Act are quoted herein under, my lord, here reproduced, my lord. I may be allowed to read out, or my lord, just my lord. My lord, registration. This is for new registration, my lord, Section 7. The registrar, upon being satisfied that the memorandum and the regulations accompanying it comply with the requirements of this Act and the rules, and upon payment of fee referred to in subsection 2 shall certify under this hand and seal that the society is registered under this Act. There shall be paid to the registrar for the registration of a society under this Act a fee of 100 rupees or such smaller fees as the state government may from time to time direct. An appeal shall lie to the state government against an order of the registrar refusing to certify the registration of an association as a society under this Act, and the decision on such appeal shall be filed in. Section 12. Society is to have power to amalgamate with another society. Whenever two or more societies desire to amalgamate, the governing body of its such society shall submit a joint proposal in writing to the registrar for his prior approval thereto. No such proposal shall have effect unless the proposal with the modification, if any, suggested by the registrar is confirmed by 3/5 of the joint members of the societies concerned, and appeal shall lie to the state government against any order of the state government on such appeal shall be final. On the proposal being confirmed, the amalgamated society shall be registered under its new name. The registration of the amalgamating society shall be cancelled. The assets and liabilities of amalgamating society shall be the assets and liabilities of the amalgamated society. Thus, it is clear that whenever two or more societies desire to amalgamate, the governing body of this society shall submit a joint proposal in writing to the registrar for his prior approval. In the case on hand, Hockey Manipur has fulfilled the provisions of Section 12 of the Act of 1989 and accordingly got registered. My lord, the sections have been analyzed in the foregoing paragraphs also, my lord. I will come, my lord, to section 10, that is page number 2743, next page, my lord, at paragraph number 3. Internal page 42, my lord. My lord, whereas section 10 of the Manipur Societies Registration Act 1989 lays down as under. Name of society. No society shall be registered under a name which is identical with or too nearly resemble the name of any other society or anybody corporate which has been previously registered or incorporated under this Act or an other law for the time being in force, as the case may be or is deemed to have been registered under this Act. And whereas section 11 of the Manipur Societies Act, this is the power given to the state for the change of the memorandum alter its name. My lord, here in the present case, my lord, in 1976, there is a Manipur Societies Registration Act, my lord. My lord also have the rules and act as placed before, my lord. Act and rule, my lord.
Which is the eighth Lord I have. This is the, Lord, I have copy on the lot of material that I have the copy.
My lord, I may be allowed to refer to the Act 1989.
From that we have,
Yes, my lord. My lord, in that, the Manipur Societies Registration Act 1989, there is a section 32, last page of the Act. Last page, section 32, repeal and savings. The Societies Registration Act 1960, in its application to the state of Manipur, is hereby repealed. Next, 2. Any society registered in any place within the state of Manipur under the Societies Registration Act 1860 shall be deemed to have been registered under this act, and its principal office shall be deemed to be the registered office of the society. My lord, the two associations, that is Manipur Hockey Association, which was registered in 1976 under the All Act, and the Manipur Women's Hockey Association, which was registered in 1976. My lord, this is still in existence, my lord. As per, my lord, section 10, my lord. No society shall be registered under a name which is identical with or too nearly resembles the name of any other society or any body corporate which has been previously registered or incorporated under this act. The All Repeal Act, my lord, which has been registered by the two associations, is still in force, and which has been previously registered or incorporated under this act, or any other law for the time being in force, my lord. This shows that the Manipur Hockey Association, Manipur Women's Hockey Association still exists, my lord. And the similar name that comes in 2009, that is registered on 12th November 2009, is similar to the Manipur Hockey Association, that is Manipur Hockey, later on come. This similarity, this is not allowed by section 11, my lord, which too nearly resembles, my lord. Then my lord, referring to that section 1011, the Secretary Cooperation passed that impugned order 22 January 2018, my lord. My lord, coming to the judgment, my lord, some continuation of page number 27/46. Page 46, 27/46. As stated, supra, when Manipur Women's Hockey Association and Manipur Hockey Association were the existing registered societies, the registration of similar society under the name and style Manipur Hockey was done. That too, after the amalgamation process was initiated as per section 10 of the act, no society shall be registered under a name which is identical with or too nearly resembles the other, my lord. This is the judgment and order. And paragraph number 56, my lord. Paragraph number 56, that is 27/51. It is true that these are the concluding part of the Honorable Single Judge order. It is true that Manipur Hockey has conducted many tournaments at different levels in the state, and equally Hockey Manipur has also participated in various national and international level hockey matches. That is not the issue to be decided in the present petition. Therefore, this court has not delved into the issue for conducting of tournaments and participation of Hockey Manipur and Manipur Hockey at different levels in the state. Once an identical name exists where a society association can be registered under the identical or too nearly resembles is the point to be considered in this case. The issue is, my lord, this is the issue, my lord. In this regard, as stated supra, Section 10 of the Act clearly prohibits registration of such society which is identical with or too nearly resembles. It is the admitted case of the Manipur Hockey that at the time of its registration, Manipur Hockey Association and Manipur Women's Hockey Association were in existence, which were up to 1976 registered. It is clear from the material produced at the time of formation of Manipur Hockey under Section 7, Clause 1 of the Manipur Societies Registration Act, the two societies, namely Manipur Hockey Association, Manipur Women's Hockey Association, were in existence, and thus there is gross violation of Section 10 of the Act of 1989 in registration of Manipur Hockey. Finding that Section 11 of the Act provides change of name, the Secretary Corporation has rightly directed the Manipur Hockey to change its name. At this juncture, it is pertinent to mention that Hockey Manipur has been formed by way of amalgamation of the erstwhile Manipur Hockey Association and Manipur Women's Hockey Association under Section 12 of the Act, and their amalgamation process started way back in January 2010, that is before registration of Manipur Hockey. Due to the existence of the Hockey Manipur and Manipur Hockey in the state of Manipur, really it not only causing confusion, and in effect the game of hockey in the state is at stake. Since the Hockey Manipur is an amalgamated of the previous two societies which were registered in the year 1976, it would be appropriate to continue Hockey Manipur in its name for betterment of hockey game in the state of Manipur. Since the registration of Manipur Hockey is in violation of Section 10 of the Act of 1989, the Secretary Corporation has rightly directed Manipur Hockey to change its name and alter its memorandum within 3 months. The aforesaid view and conclusion arrived at by the Secretary Corporation is in the interest of both Hockey Manipur and Manipur Hockey. This court is of the view that such a conclusion arrived at by the Secretary Corporation is based on in-depth examination and consideration of the substantive points put forth by both the parties, and also taking into consideration that both Hockey Manipur and Manipur Hockey have committed and produced many of the players. In view of the categorical finding arrived at by the Secretary Corporation and the issuance of the impugned order, this court finds that there is no infirmity in the impugned order dated 22nd/1/2018. That apart, the ground taken to challenge the impugned order by Manipur Hockey is not sustainable in the eye of law. Therefore, the impugned order dated 22/1/2018 needs to be implemented as directed by the Secretary in the impugned order dated 22/1/2018. If implementation is done, really no prejudice would be caused to Manipur Hockey. On the other hand, if it is not changed, the concept of amalgamation of two older societies as Hockey Manipur is meaningless. For the foregoing discussions, this court is of the view that the impugned order dated 22/1/2018 has been issued by the Secretary Corporation pursuant to the series of order passed by this court and the letter correspondence of the respondent authorities. Therefore, there is no ground to interfere with the impugned order dated 22/1/2018. In the result, WPC number 916 of 2019 is dismissed, which was filed by Manipur Hockey. Number 2, WPC number 724 of 2019 is allowed, which was filed by Hockey Manipur. The respondent number 1 and 2 are directed to implement, execute the order dated so and so passed by the Secretary Corporation Government of Manipur, and the letter dated 14/1/2019 issued by the Registrar of Societies Manipur within a period of 2 months from the date of receipt of copy of this order. Since WPC number so and so is dismissed, the interim order dated so and so and its subsequent extension shall stand vacated. My lord, there is a letter dated 14/1/2019 which is mentioned by the Honorable Single Judge. My lord, that will be found at, my lord, page number 14. Yes, page number 79, my lord. Page number 79. Yes. Yes. My lord, why it is referred by the Honorable Court, my lord? My lord, the page number 77 will be relevant. My lord, the Manipur Hockey file WPC number 124 of 2018. My lord, may I please read? Page number 77, my lord.
77.
Because in the judgment order, my lord referred, single judge referred the order letter that 14/1/2019. I would like to make it clarify. Page number 77, man. My lord, WPC number 124 of 2018 is filed by Manipur Hockey, challenging the same impugned order 22/1/2018, which was dismissed as non-joinder of necessary parties. Before that, the Honorable Court passed the interim order in the same WPC number 124 of 2018. That is at page number 77, order dated 27/11/2018, my lord. My lord, next page, that is operative part. Page number 78. My lord. Last paragraph. While considering the method to find out an amicable solution, it is open to the registrar societies to invite the Hockey Manipur so that the issue can be resolved for once and all. After considering the views and suggestions of all the parties, the registrar societies shall submit a report to this court on or before 16/1/2019. The registrar society shall submit a report. In pursuance of this order, the registrar of societies, my lord, submit a report dated 14/1/2019. That is found at page number 79, my lord. That is found at page number 79. This is the report as per the Honorable Court's order to submit the report. My lord, the type 1 is at page number 80. May I please read out, my lord? My lord, this is also very relevant, my lord. In compliance to the Honorable Court's order, High Court of Manipur dated 27/11/2018, passed in WPC number 124 of 2018. That is the order just I referred. A meeting has been conducted on 17 December 2018, and both the parties came for the meeting, 9 members from Hockey Manipur, 2 members from Manipur Hockey. The 2 representatives from Manipur Hockey said that they will not be in a position to take any responsibilities, decisions, and that the meeting be postponed. However, as the representatives from Hockey Manipur had come in full strength, and also prior information about the meeting had been served to both meeting notice dated so and so, dated 10 December 2018, Manipur Hockey coming only at that time of the meeting seeking postponement is not acceptable to this office, as it is a deliberate attempt to foil the meeting. Hence, it may be stated that reconciliation looks non-feasible at this juncture, and hence the following facts are stated as below for arriving at final solution. Left and right, my lord, margins. The Manipur Hockey Association, the Manipur Women's Hockey Association, formed in the year 1976. As per instruction from Indian Olympic Association, the Manipur Hockey Association and Manipur Women's Hockey Association got amalgamated. Hence, with this, the separate registration number of men and women done away with. Instruction from IOA was given to form one game, one body on June 1, 2009. As per the instruction, both the Manipur Hockey Association, Manipur Women's Hockey Association came to a conclusion for the formation of Hockey Manipur. Amalgamated already in 2009 on 28 June, while the registration number was given on 21st January 2010 after following all the process of registration. Right side, my lord. While the process being done for registration of one body, Manipur Hockey was given registration by the RCS on 12 November 2009, RCS Registered Cooperative Societies, my lord. Became an entirely new body with no representatives from the previously existing bodies. There is no amalgamation as such. Only 5 days were given after the advertisement for registration of Manipur Hockey. Before the registration was done in violation of Rule 13 of the Manipur Societies Regulation Act 2004. Further, their notification was objected by the Secretary Hockey Manipur on 2 occasions. 13 October 2009, 6 November 2009, well ahead of the registration being issued on 12 November 2009. Manipur Hockey was registered on 12 November 2009. Objections were given on 13 October 2009 by the respondent Hockey Manipur. Accordingly, the Principal Secretary also deregistered Manipur Hockey. However, the same was withdrawn by the order of the Honorable High Court dated 31/7/2017. The Secretary Corporation had also directed Manipur Hockey to change its name on 22nd January 2016 within 3 months, but this order is stayed by the Honorable High Court of Manipur dated so and so. Further, there is no record of no objection certificate from Youth Affairs and Sports, being the parent department. NOC is usually sought from only one letter from the then Director Yas addressed to the additional registrar society seeking classification as to the objection being invited or not. The letter is dated 10 December 2009, way after registration was done. My lord, the Department Youth Affairs, my lord, sought the no objection certificate from the RCS, my lord. My lord, next page, my lord. At this juncture, as directed by the Honorable Court to consider both the facts and present it before the court, the following is stated. Hockey Manipur is the legal entity as it is the amalgamated unit from both men and women as per condition of IOA. Though registration number was accorded for this amalgamated body in January 2010, having followed all the existing rules and procedure. However, Manipur Hockey has violated the norms of registration, Section 5, Section 10, Section Rule 13 of the Manipur Societies Registration Act and rules, and hence it is illegal. This is the report submitted by the Registrar of Cooperation, my lord, as per the Honorable Court's order, my lord. Yes, which has not been challenged, and the Honorable Court also, my lord, the allowed this research, my lord, as per the judgment and order of the Honorable Court. My lord, the facts, my lord, why, my lord, the two associations were to be amalgamated? Why, my lord, this in the year, my lord, yes, my lord, on 1st June 2009, my lord, the president of the IOA, my lord, for the all India, my lord, there are women's association as well as men's association for all over India, my lord. To done away with that, only one body should be there for one game. The principle, one body, one game, one association, one game should be there. That has been adopted, my lord. And in compliance of that, my lord, the in the state of Manipur, my lord, as meeting also held in the Pune, my lord, for 23, 24 states to done away with two associations in one state, in its every state. In Manipur also, my lord, to done away with that, the Manipur Hockey Association, which were in the for men's, my lord, that is 1976. And for women, that is Manipur Women's Hockey Association, that is of 1976. They were to have only single one body in order to form one body amalgamation proceedings, my lord. The Hockey Manipur, they have taken up many steps, my lord. While doing so, my lord, in the midst of that procedure, the Manipur Hockey, my lord, submitted the proposal, my lord, for registration of the Manipur Hockey, and the registration was given on 12 November 2009, while there is still process of the amalgamation, my lord. And yes, amalgamation, and later the Hockey Manipur was allotted the registration for Hockey Manipur in the on 21st January 2010. That is after 2 months, my lord. Yes. My lord, going to the, my lord, law points also, my lord, there are some law points involved. My lord, in the present, these petitions, two petitions, my lord. I may be allowed to, my lord, refer the counter affidavit. My lord, counter affidavit file, my lord, in the writ appeal, my lord, that is of 27. We have filed the counter affidavit. In writ appeal, my lord, 27. The thick one, my lord.
Hmm?
The thick appeal, my lord. Counter affidavit for the state will be found at page number 169. Page number 169, annexure R39. page 169 and XR R39. My lord. Page 160. Yes. My lord, relevant portion, my lord, I will refer, my lord, page number 162, paragraph number 3.
Hmm?
Page 172, relevant portion, I will refer the counter, my counter of the state. My lord, paragraph 3, page number 172. Then before giving pairwise reply to the contentions and allegations made by the writ petitioner in writ petition, the documents, deponent grabs slip of the honorable court to state the following facts for better appreciation of the honorable court. On 23rd 10 1976, Manipur Women's Hockey Association was registered being so and so. Similarly, on 26th 10 1976, Manipur Hockey Association was also registered under the so and so. On 12/11/2009, the writ petitioners association, namely Manipur Hockey, was registered under section 7(1) of the Manipur Societies Registration Act, so and so. On 21/1/2010, the earlier two societies, namely Manipur Women's Hockey Association register number so and so, and Manipur Hockey Association, have been amalgamated into one society in the name of Hockey Manipur, the private respondent number 3 in the present case, under section 12 of the Manipur Societies Registration Act, and allotted the registration number for so and so on 21st January 2010. The Manipur Societies Registration Act 1999 was framed and published in the official gazette on 17/3/1990. Some of the provisions which are relevant for adjudication of the present writ petition are reproduced herein below for better appreciation of the honorable court. Section 7, which I already read out, for new registration of the society. Section 10, no society cannot be registered. It is too nearly similar name. Section 7, power of the state government to direct, to change or alter the memorandum and its name. Section 11. Yes. And section 12 is for the amalgamation of the two societies. Section 32 also here referred, which I referred earlier, man. The repeal of the earlier act and incorporation of the societies, man. My lord, in the pairwise reply, page number 7, next page 8, internal page. Internal page 8, page number 177, running page, man. Paragraph 5. That with reference to para number 8 and 9 of the writ petition, the deponent begs to submit that when the petitioners association submitted its application to the respondent number 2 for registration of their association, namely Manipur Hockey, under the Manipur Societies Registration Act 1989, the respondent number 2 and its officials, through bona fide mistake, my lord, have not properly examined and verified the existence of similar or nearly similar name of society, which has been previously registered in the name of Manipur Hockey Association under registration number so and so of 1976. And as such, respondent number 2 granted the certificate of registration bearing number so and so on 12 November 2009, my lord. It should not be 19, it should be 9, to the petitioners association, that is Manipur Hockey. While existing 1976 registration, through bona fide mistake, the registrar of society granted the registration, my lord. Here it is very clearly reflected, my lord, through bona fide mistake. Therefore, it is submitted that the certificate of registration granted to the petitioners association on 12/11/2019 was against section 10 of the Manipur Societies Registration Act, and accordingly the state government is in exercise of the power conferred under section 11 of the Manipur Societies Registration Act, read with rule number 14 sub-rule 9 of the Manipur Societies Registration Rules, issued the order dated 22/1/2018, impugn order, thereby directing the present petitioner, that is Manipur Hockey, to change its name and alter its memorandum within 3 months from the date of receipt of the order. My lord, this is the relevant. Others I have repeated, my lord, in the previous also, my lord. Yes. Yes. They have not filed the rejoinder also. In the 724 filed by the Hockey Manipur, the other respondent, my lord, they have not filed the counter affidavit also in 724 WPC number. Uh, uh, My lord, the counsel, my lord, for the appellant, my lord, file a new additional affidavit, my lord, bringing into records the information obtained through RTI. My lord, as I have stated earlier, my lord, as per the honorable court's direction, I have the orders, my lord. The honorable court directed to produce all the relevant records pertaining to the impugn order as well as registration of the two societies. And I produced, my lord, and they were given liberty to inspect and go through the document records in the registry of the Honorable High Court of Manipur. After perusing all the records, the Honorable Court passed this order and bringing into record additional affidavit at the writ appeal stage that will not change the judgment and order which had been passed by the Honorable Single Judge. This is my humble submission. After referring all the documents and record, the Honorable Court passed the judgment and order whereby stating that the Hockey Manipur is legal and the Manipur Hockey is not legal. My lord, in the submission, my lord, in the writ petition filed by the Manipur Hockey, that is WPC number 916 of 2000, my lord, 19, filed by the Manipur Hockey. My lord, in the prayer, their prayer is just to pass and set aside the order of the secretary, my lord, 22/1/2018 impugn order, and to dispose of the representation, my lord, filed by them. There is no whisper. There is no whisper of challenging the amalgamation in the writ petitions. There is no whisper at all. And my lord,
No challenge.
yes, they have not challenged. There is no whisper at all challenging the amalgamation. They have not challenged. My lord, please. My lord, yes. My lord, please come to section 12 of the act. Section 12 of the act. Yes, section 12 of the act. My lord, clause number 3. This is in relation to the amalgamation. Clause number 3, section 12. An appeal shall lie to the state government against an order of the registrar, my lord. This is printing mistake, I guess, my lord. On such appeal shall be final. My lord, if there is any question, if they want to contest, they want to protest, they have to go to the state, my lord.
How do you say it's a printing mistake?
No, my lord, this of the state also, my lord, this is not related, my lord, because in the most of the provisions, my lord, this is not related. I'm just submitting that against the order of the state, because in the section 7, clause 3, because I would like to just clarify that one only. This is nothing related with the merits of the case. Section 7, clause 3, an appeal shall lie to the state government against an order of the registrar. All the order of the registrar, appeal will lie to the state government. My submission. They have to, if there is any grievance against the amalgamation, they have to go to the state. This is my submission. Yes. They have to approach the state with respect to amalgamation.
Must be a printing.
Against the order of any, my lord, amalgamation, any grievance, they have to approach the state. which they have not done so. And there is no whisper in the writ petition 916, my lord. And my lord, the objection also, my lord, that will be, I just want to refer because my brother,
This order was passed by the secretary.
yes,
The state.
yes, this is the impugned order. My lord, they have say, asked for the amalgamation is wrong.
Appeal before whom?
Amalgamation is wrong, they said.
No, appeal before whom? As per section 12(3).
12.3, my lord, they have to approach to the commissioner, my lord. That is that, this relates to the amalgamation. They are saying that amalgamation is wrong in the submission. If it is wrong, they have to go to the state, which they have not done so. This is my submission, my lord.
From secretary to commissioner.
Yes, yes.
Do you have the rules of executive business?
Registrar of Cooperation, man. Registrar of Cooperation, any,
Do you have the rules of executive business?
right now, I don't have my,
Because you said it's a mistake.
no, or as it is,
Subject.
or as it may be, my lord. I will not say that, my lord, or it may be.
That cannot be.
No, my lord, an appeal
Sir,
shall lie
like
to the state
this-
government against any objection made by the, my lord, section 12. An
Any-
appeal shall lie to the state government against any order of the state government on such appeal shall be final.
Yes.
This provision they have not opted. Whether this is
That's
true,
what I said. It's maybe mistake, it's maybe wrong.
whether my lord, my humble submission, whether it is a mistake or not, this provision have not been
I just
opted.
wanted to know why. Is it a mistake or is this?
My lord,
is it-
my opinion, my lord, it should be from registrar. Because in all the other provisions, the appeal goes to the state, my lord, from the registrar.
No, but the impugned order was passed by the state now.
That is with regard to the 22/1/2018.
Ah,
That they are saying that the amalgamation, my lord, already amalgamated and it is correct, my lord. That they are saying amalgamation is wrong. If amalgamation is wrong, they have to go to the, my lord, appellate forum, my lord, state. They have not gone to the, my lord, secretary commissioner, my lord,
No,
stating
21,
that the amalgamation is
see,
wrong.
21 January 2018 passed by the whom?
22 January 2018, it is passed by the secretary, my lord.
Secretary.
Yes. Stating that amalgamation is correct.
Secretary is not,
State.
not a state.
Is a state.
Then
No, my lord, I would like to say that, my lord, that is another aspect, my lord. 22/1/2018 is passed by the state,
No, no.
saying that the whole process of the amalgamation is correct. Manipur Hockey
there is.
Association registration is wrong.
No, that is correct. But
Yes.
since you have taken up this,
Appeal.
the
Yes.
provision of subsection 3
Yes.
has to be, there has to be some clarity.
Yes. My lord, they have to take.
It's your own act. Are you saying it's wrong?
My lord, my lord, in my opinion, it's because in all the other provisions they have referred, my lord.
no, see, Athava, since you have already said that they have not appealed, filed an appeal.
Yeah,
Now this 22/1/2018
18, Yeah.
is an order by the state government
secretary, yes.
secretary.
Yeah.
Now under section 3, section 12,
Yes,
subclause 3,
my lord.
to whom will an appeal go?
My lord, an appeal shall lie to the state government as per the provision. An appeal shall lie to the state government against any order of the state government on such appeal shall be final, my lord. This is the wording written here, my lord.
Something is wrong.
What do you mean by state government?
Pardon, my
What do you mean by state government?
state government. My lord, commissioner, secretary,
Not the secretary.
they are the state. Yes.
Then this order is passed by the secretary.
My lord, against the order of amalgamation, against the order, if they are aggrieved, they have to approach
Yes, to whom?
to the state or secretary or commissioner, which they have not done so.
Who is the state?
My lord, secretary, commissioner, my lord.
Your provision says Government against the order of the state government,
Yes.
before the state government.
That,
That it mean.
that meaning, my lord.
Let me.
This is a legislation,
Yes.
you cannot change it.
My lord,
The state government also cannot change it.
my lord. If it is
Milord,
true and correct.
regard to Milord, you made it very carefully, Milord. Societies to have power to amalgamate with another society. It is relating to the proceeding of the amalgamation. It's not in respect of the order issued by the state. Amalgamation of the Manipur Hockey Association and the Manipur Women Hockey Association in regard of the debt only matter, not that 22.
22-1-18.
That
Not
is,
with
that is
relation.
my understanding,
Yes,
my lord,
yes.
subject to correction.
Yes.
That is, to my understanding, my lord, subject. to correction.
And my conclusion, my lord, the judgment and order passed by the honorable single judge, my lord, is valid, legal, and may be confirmed by. Obliged.
Lordship, the private respondents, my learned friend wants to submit something, then let him submit. If you want to supplement something, otherwise, my lord, it will be my rejoinder to their reply. Then the submission will be completed. Also. So if they want anything, my lord, let it them, so I can give a full rejoinder to their submissions or also replies. Otherwise, I'll stop.
Not for me, Lord. For me, Lord, I have absolutely.
No, issue is, you have completed your argument.
Yes, Lord. But then
If you want to supplement some more,
oh, yes,
then you can do it now.
Lord.
After that, Biswajit will
Yes, your lordship.
give the final
Yes, Lord.
reply. And
Yes,
then,
in that
we
case,
can
my lord, I'm ready. In that case, I'm ready. Yeah, yes. Lord,
If you have nothing to submit, it's okay.
my lord, it's okay, my lord, there are
Okay.
certain things which I would like to place before lordship. It's a very, within a short parameter, my lord, I try my level best to. Lord, the very case still pending before this court. This was, my lord, the judgment, my lord, passed by Honorable Justice, my lord, Murali Dhar, my lord, that is, lordship may kindly have a look, my lord. Judgment, no? Lord, dated 27/2022. The page 35(3), my lord, may I refer to read appeal number 96 for the Impal and the 27 for the Guwahati.
So which bit?
My lord, appeal number 27 of 2023, put it out. She going to let me.
Page?
My lord, page 35/3. my lord.
Page 35.
Right there, though. So, I think it's not the way it is. Lord, lordship hates, man. Lordship hates. Now, my lord, order dated 27/2022 in respect of the two petition, my lord, WPC number 916 of 2019 and 724 of 2019. These two cases was disposed of on 27/2022. How it was disposed of? Because of the material placed before the learned judge. Before the learned judge, the material placed before the learned judge, this order is the output of those material placed before the learned judge. That was passed on 27/2020. Now, my lord, additional affidavit has been filed by the appealant only on 12 October 2023, saying that, your lordship, let me refer to the additional affidavit
to the writ appeal 27 of 2023. How it was filed. My lord, that 27 of 2027 writ appeal, my lord, additional affidavit filed on 12th October 2023. Lordship got it. My lord, is your lordship,
Additional affidavit.
additional affidavit of the appellant filed on 12th October 2023. Lordship got it. Got it.
Is it the page? No.
My lord, it is not pace. My lord, it should be my lord IA or something like that. Ah.
IA number?
28
Huh?
28 October. No. My lord, for me, my lord, my record that mentioned 12, mention is 12 October 2020. And your lordship order, my lord, it must be 28 October 2023. As per the information from my junior.
Filed on 19th October.
My lord, must be, my lord, must be. For me, my lord, 12. They have written 12. They have written 12. Lordship got it.
Hmm.
Now, dear your lordship, may kindly see.
1 minute, 1 minute. Yes.
Here, my lord, how it filed, how it was filed without the legal people. Normally, my lord, the facts, if the appellant wanted to place before the division bench, then if there be the fact which was never been considered before the learned judge, single judge, how the process should be done before filing this additional affidavit, there must be some miscellaneous application taking permission from this honorable division bench, allowing to be treated as part of the record, but that was not done. And my lord, to my understanding, my lord, I may be wrong to my understanding. This is my humble submission for consideration by your lordship. The lordship consideration. Now, second thing is that, my lord, page 8. Page 8, my lord. Page 8 of the additional affidavit, dated 30th January 2023. This is the application seeking certain information from the RT, information for getting certain papers and information from the relevant officer. Now, that was on 30th January 2023. Now, the judgment order was passed on 27, 2022. Now, they got some papers, my lord, saying that amalgamation proceeding, there was some irregularity. there was some irregularity in amalgamation proceeding of the Manipur Women Hockey Association and Manipur Hockey Association. So therefore, amalgamation process is illegal. Therefore, since the very beginning, amalgamation is non-existence, null and void. Void of an issue. They are saying that, whether it is permissible at the juncture. Now, these very materials, my lord, produced subsequently by filing the additional affidavit before the division bench, whether it is permissible under the law. If that be the true, this is the true, assuming not admitting, whether it is permissible. Now, after reading this information, my lord, supplied by the authority, deputy registrar, to the appellant, stating certain things, which is no record, this and that. Now, let me refer to the writ appeal. There are 3.1 page, internet page 18. The contention of the writ petition appellant before the learned single judge.
Writ appeal?
Writ appeal number, my lord, 27 of 2023. 6 contentions are there in the writ appeal, my lord. Internet page, my lord, 618, your lordship, of the memo of appeal.
Huh?
Memo of appeal, my lord.
Memo of appeal.
Memo of appeal 27 of 2023. Lordship got it. Lordship has page 18. Page 18, my lord.
18.
18, 1 8. And you also may find contention of the writ petitioners. Lordship got it. Page 18 minutes. Contention of the writ petitioners appellant before the learned single judge. Lordship got it. Page 18. How?
I'm so sorry, my lord, for interference, your lordship. My learned friend, my lord, has wrongly, my lord, trying to misguide this honorable court, saying that regarding the additional affidavit, he himself was present, my lord, on 12/10/2023. The order speaks like this, your lordship. The then Chief Justice, my lord, 12/10/2023, London Council appearing for the appellant submits that the additional pleading is required to be filed on behalf of the appellant, and thus a short opportunity may be granted to this purpose. Mr. Athuba Khaidem, London Additional Government Advocate, Manipur, representing the exponent number 1 and 2, and Mr. Hemchandra, Senior Advocate himself, and Mr. Jain Sayawala, the Senior Counsel, appearing representing the exponent number 3, do not object to the prayer so met.
My lord, what I'm trying to convince is that, my lord.
Well, it's completely wrong. There is no
Lord,
leave. We have prayed to this honorable court.
leave is
Allowed us.
required.
No, allowed us.
If
to
your
file.
lordship is allowed filing the additional affidavit, but the miscellaneous application for allowing to file leave is required. I know the existence of the order, my lord. I am not misguiding your lordship. My good friend is saying that I am misguiding, my lord. This is absolutely, I'm extremely sorry. And then, my lord, what I'm saying is that the Honorable Chief Justice passed order. However, my lord, that misapplication allowing,
We filed additional affidavit.
no, miscellaneous application
Just-
allowing to file
Some documents.
leave is
Just allowed by this
required.
honorable court. And it's not a civil suit, your lordship.
Huh?
Once the honorable court allows, my lord, there is no question of, my lord, as my understanding, to move an application.
My lord, after that, my lord, the misapplication is required to file because filing the leave. This is the order passed by the Honorable Chief Justice saying that, okay, you can file the additional affidavit. But there is a procedure for filing the additional affidavit. If that be the case, if that be the facts, then the miscellaneous application is required to take leave for filing the additional affidavit. That is my understanding, my lord. If this is for consideration of your lordship, my lord. My contention is that, my lord, for consideration by your lordship only, my lord. It's up to your lordship, whether the leave application is required to file or order passed by the chief justice is sufficient, that your lordship has to be considered. Because to my understanding, my lord, if the court allowed to file the additional affidavit, there must be some application allowing to file leave application. Otherwise, everything goes without any procedure. So I'm not misleading to the honorable court. But this what is doing. Extremely sorry. I'm not misleading. I understand, my lord, the order passed by the court. So miscellaneous application file for praying for allowing to file the additional affidavit. To my understanding, my lord, subject to your lord. Now, my lord, there are three, my lord. Contention of the writ petitioner appellant before the learned single judge. Now, there are 6 contention, your lordship. There are 6 contention, my lord. That, my lord, 3.1, that the writ petitioner appellant contended that the appellant is the only body affiliated and recognized by the Hockey India and MOA for the sports of hockey in the state of Manipur. In fact, it is the only body who have been conducting tournament. Coaching camp at different level in the state of Manipur, including national championship. And on the other hand, the Hockey Manipur, who possesses to have been established with the objective of promoting, encouraging an all-round development of the game of hockey in Manipur to hold inter-district and other state level tournament, to conduct courses for the coaches and trainers, etc., have not undertaken not a single activity worth it named till that in pursuance of its objective for which it was established registers, except for creating hurdles in the smooth functioning of the appealing society. In other words, the Hockey Manipur exists only in paper. That was the first contention before the learned single judge. The second contention was that, my lord, that the writ petition appellant contended that the impugned order dated 22/1/2018 had been issued by the respondent number 1 in a very arbitrary and malified manner in the colorable exercise of power with an ulterior and the preconceived motive to cancel the registration of the appellant, in as much as the impugned order had been issued more than 8 years after the Manipur Hockey Association and Manipur Women Hockey Association have ceased to exist on 29/6/2009. This is also absolutely incorrect after reading the reports. When the order for amalgamation of the said two society was issued on with effect from 21/1/2010, when the registration of the two said association have been cancelled by the register of society. These are the second contention before the learned judge. Now, third contention is that the writ petition appellant contended that the registration of Hockey Manipur and the Manipur Society Registration Act was allowed only on 21/1/2010, much later than the registration of the appellant, which was allowed on 12/11/2009. In view of this such undisputed fact, the invocation of the provision under Section 11 of the Manipur Society Registration Act 1989 and Rule 49 of the Manipur Society Rules 2004 by the respondent number 1 against the appellant instead of against the Hockey Manipur, that too by totally ignoring the application dated 29/12/2017 submitted by the Manipur Hockey, is very much arbitrary, malified, and the same has been done in colorable exercise of power with an ulterior and the preconceived motive to cancel the registration of the appellant at any cost by hook or by crook, and impugned order had been issued illegally and without any authority of law. Now, third contention, it talks about issuance of the very order said to be impugned order matter. Now, fourth contention. This fourth contention, my lord, it is very general contention, just I have put it out, that the writ petitioner appellant contended that the impugned order had been issued with a malified intention to scuttle the promotion, propagation, and development of the sports of hockey in the state of Manipur, in which the appellant has been and is deeply engrossed with, as will be shown by the fact that because of its credential, it is the only recognized body for the sports of hockey in the state of Manipur by Hockey India, which is apex body for the sports of hockey in the country, and has been conducting several activities, including hoisting of several state level as well as national championship in the state of Manipur. Further, from a narration of the facts stated in the foregoing paras of this appeal, it will reveal that respondent one issued the impugned order in tolerable exercise of power and at the instance of dictation of the Hockey Manipur. Now, this is the fourth contention. It is general contention. Now, fifth contention is that the writ petitioner appealant contended that the impugned order had been issued by the respondent one with an ulterior preconceived and the premeditated motive to cancel the registration of the appealant as will be shown by the facts narrated above and on a plain reading of the order which is accompanied by the threat to cancel the registration in the event of not doing in the particular way it is directed to be done within the time stipulated in the order. This is also general contention. Number 6, my lord, that the writ petition appellant contended that the respondent number 1 or for that matter, the respondent number 2 has not taken up any action against Hockey Manipur on the basis of application of the appellant dated 29/12/2017 or changing the name of its association or for cancellation of their registration, knowing fully well that the same is a defunct society existing only in the paper and not engaging any activities word in name commensurate with each aim and object for which it was set up and registered and renewing its registration in connivance among the respondents. On the basis of the false and concocted document, it is also submitted that respondent 1 and 2 are stopped to their conduct from issuing and said impugned order as shown by the facts stated in the foregoing paragraphs and document annexed herewith, along with the appeal. These are the contentions, 6 contentions before the learned judge. This very contention has been precisely, answered by the government, state government. Now, is there any contention for illegality and the irregularity of amalgamation? Was there any argument? Was there any paper for illegality or irregularity in the process of the amalgamation of the two 1976 body, oldest body of in respect of the hockey discipline? Was there any contention? Nothing. Was there any paper? Nothing. How the learned single judge pass order saying that this amalgamating body is incorrect, it has not been done under the procedure established by law as per the Act and rules, because the records was never been placed before the judgment. So now, my lord, after passing the order, learned judge order, my lord, material available before the court, learned judge, the learned judge pass order, single judge pass order on the basis of the material. Now, at the stage of the writ appeal, my lord, they filed additional affidavit saying that, my lord, these are the irregularity committed while amalgamating the two bodies, whether it is permissible, whether it is permissible under the law. And then, my lord, with the leave of the court, but then I'm saying that, my lord, that with the leave of the court, whether the Honorable Chief Justice of Honorable Guwahati High Court pass order saying that yes, appellant is allowed to file the additional affidavit, and we do agree. But is it sufficient? Directly file the additional affidavit, my lord. Is there any requirement of filing the misapplication allowing to file? Otherwise, my lord, to my understanding, I may be wrong. This contention is your lordship consideration. And now, as per the Order 49, Rule 27 of the CPC. Sorry. Well, Order 49, Rule 27.
Order 40,
Order 49, Rule 27, your lordship. Order 49, Rule 27, not wrong. What you got? Heading is that, Millard, production of additional evidence in appellate court. What you got? Now, Production of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court, but if the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted, or the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appeal against was passed. The appellate court required any document to be produced or any witnesses to be examined to enable it to pronounce judgment or for any other substantial proof. The appellate court may allow such evidence or document to be produced or witness to be examined wherever additional evidence is allowed to be produced by an appellate court. The court shall record the reason for its admission. Now, the learned, my Lord, Chief Justice of this court, my Lord, allowing to file the additional affidavit. Now, we did not object, let them file the additional affidavit. However, there are some certain standard procedure. My Lord, my contention is that whether they follow the standard procedure, I am not misleading the court. I do not have a right to mislead, and I do not have a power to mislead the court also. This is very word used by my good friend Miller. It's very important. Now, these are the contentions, 6 contention, my lord, who is never raised before the learned judge. So now they wanted to brought certain facts after passing the orders, my lord, whether that these facts could be considered at this stage. Now, another point is that, my lord, in this regard, as I have stated earlier when I argued before your lordship, there are one writ petition pending before the court, before the learned judge, learned single judge at Impal Plains. And I filed the miscellaneous application that I do remember, my lord, that the record must be there because I have supplied to your lordship. And then I filed the misapplication.
Petition number?
697 of 2023, my lord. That must be there, your lordship. Lord, I have filed the objection there too. And what they have read, dear my lord, the representation which was dismissed, praying inter alia to reconsider that representation, my lord, by filing the reminder representation. Constructive res judica, which I have raised, and I have filed the miscellaneous objecting for filing, allowing to admit the writ petition, my lord. That must be dear, your lord. I have supplied. I have supplied. Now, my lord, the last occasion, your lordship, this writ petition was placed before the learned judge. And then on that day, the objection was filed on that day. And then I'll furnish to your lordship just for your lordship appreciation, my lord. Saying that, my lord, something goes wrong, my lord. Just to, my lord, see the objection filed by the appellant to my misapplication, my lord, objecting or refusing to allow the writ petition pending before the learned judge. Now, these are the 6 contention, my lord, before the learned judge. What my contention before your lordship is that, my lord, whether it is permissible to consider these subsequent documents. At the same time, my lord, they have filed the writ petition saying that, my lord, the cancellation of the Hockey Manipur, which was registered in 2010, and they filed the writ petition in 2023, after 13 years. And there is a provision for appeal also, statutory appeal, enshrined under the relevant act and rules. That has not been done yet. And the representation, reconsider the representation, referring the earlier representation, which was dismissed by the learned judge, learned single judge. That is the 2 prayer of the writ petition filed by the appellant and pending before the learned judge. at Imphal East. Now, these are the contention, my lord. Let me refer to the grounds of the memo of appeal. It's a very ridiculous matter. Let me refer to the grounds. These are the contention. These 6 contentions are there, and let me refer to the grounds. Contention with petition. Contention with the respondent. Contention with number 3. Defining reasons. Grounds for conclusion and decision of nothing. Grounds on which the conclusion decision of the learned single judge by the appellant. Because it is in some, so I could say that it is some supplanting or implanting this thing, my lord, which has never been considered before the learned judge. These are the grounds for filing the memo of appeal. These grounds stated here, there are 2-3 grounds regarding the amalgamation, irregularity, my lord, or illegality. They could use the illegality or irregularity. While process of amalgamating of 2 unified, 2
Chandra,
bodies.
have you not argued this earlier?
My lord, I have argued, but then this is more important. But then, my lord, if I argue, then I will stop now. If your lordship convinced my argument, then I will stop now. Because,
I think you are repeating it.
but my lord,
Other day you have-
yes, my lord. In that case, my lord, I stop. I immediately stop. And then, my lord, which I have not been stated before, lordship, I straight away go to that. Page 277. Page 277. Page 277, my lord. When the registration was done, Manipur Hockey. Lordship got it, 277. Lordship has page 277, my lord.
Yes.
My lord, here, my lord, this application has been filed by Hockey Manipur, whom I am representing before lordship. Now, this very application stating that, my lord, request for this allowing registration of parallel hockey organization. That was on 13/10/2009. Before registration was taken place in respect of the Manipur hockey. Because there were 2 existing body, namely Manipur Hockey Association and the Manipur Women Hockey Association. Therefore, allowing fresh registration has been barred by the section 10 and rule 13, read with rule 13. Therefore, we have filed even before registration of the Manipur Hockey, stating that request for disallowing registration of parallel hockey organization. With due respect, my lord, let me read it because it's very short. With due respect, I, on behalf of Hockey Manipur, and unified body of the Manipur Hockey Association and Manipur Women Hockey Association, begs to request you kindly to disallow any move from other parallel organizations for registration afresh to the registered cooperative societies Manipur. In this connection, it is to apprise you that the 2 registered bodies of both the Manipur Hockey Association, registered number 2002 of 1976, and Manipur Women Hockey Association, registered number 1976 of 1976, 1996 of 1976, are amalgamated to form a new body which the Hockey Manipur are in the process of registration very shortly. This process of amalgamation is directed by the Indian Olympic Association as per instructions from the International Hockey Federation, World Hockey. Under the circumstances cited above, the unified body which Hockey Manipur is the only genuine and bona fide hockey association of Manipur after having completed the necessary formation of the amalgamation of the 2 bodies. The Hockey Manipur is also going to be registered to the registration cooperative societies Manipur very short. This was the very application submitted to the authority, register cooperative, not to allow to fresh registration, because there was a process for amalgamation and there are 2 bodies registered in 1976. So therefore, the government stated before your lordship is that through bona fide mistake. So this very existence was there, this very letter was there even before born of the Manipur.
What does the act say with regard to fresh registration?
Fresh
When there's-
registration,
when-
section 7 million.
When there's any objection?
Section 7 million. Yes, yes, your lordship is very important, million. Because there are rules, million. Standard rules is there, million. But then I'll come to that. Notification is there. Publication is there. That was not done it. I can know.
Just take a break.
In regard of the registration, my lord, or in regard of the amalgamation, registration, fresh registration. my
When
lord.
there's a fresh
yes,
registration
my lord.
and there's a.
Yes, your lordship.
And there's an objection. So what are they supposed to do?
Yes, my lord.
After 5 minutes.
Yes. Till I start.
How long?
Lord, I won't take time, Lord, with this.
No,
Lord,
that's fine.
yes,
Just
Lord,
give us the provision.
yes. My lord, the Manipur Society Registration Rule, which your lordship asked to me, my lord, I'm duty bound to give on chairman.
on it.
My lord, rule 2004, my lord, in respect of the section 7, press registration. There are procedure to be followed while registering press registration of the Manipur hockey.
Yes.
My lord. Now, page 3 of the rule 5.
Rule?
Application for rule 5.
Mm.
Application for registration under section 7 million. Because Manipur hockey registered under section 7 of the Society Registration Act 1977. Now, rule 5 talks about application for registration under section 7 and application for registration of a society shall be made to the register of society personally or by post. Such an application shall be accompanied by 2 copies of the memorandum referred to in section 5. 2 copies of the regulation of the society duly certified to be true and correct by not less than 3 members of the governing body. 1 copy of the proceeding of the general body meeting in which the following resolution shall be taken. 1. Formation of the society name, office, address. Election of the governor. 2. Election of the governing body members and office bearer. 3. Adoption of the memorandum and regulation. 4. Registration of the society under the Act. D. 1 copy of the proceeding of the governing body meeting in which the office bearer were elected from amongst the member of the governing body. E. 1 copy of the publication in newspaper inviting objection from the general public to the registration of the society. Any other document required by the register of society. G. All documents shall be authenticated by the secretary or the president of the society. Now, others document, my lord, I do not get, but I got only publication of newspaper. Now, let me directly refer to page 214 of the memo copy. How notification in the newspaper was done. Whether it is the objection calling to any association or any, body, my lord, thereby calling objection in respect of the registration of the Manipur hockey, my lord. So, therefore, in order to appreciate or whether the fulfillment of condition laid down in rule 5. Now let me directly go to the page 214 of the memo copy. 214, page 214. This is the newspaper published in Manipuri, but then, my lord, I have typed out on page 215. So she got it. So she got it. Huel Lanpao, this is my lord's Manipuri dialect and local dailies. Registration. 23rd, 10, 2009. under the instruction of Hockey India for the development and welfare of hockey discipline in Manipur, one association called Manipur Hockey is going to register. He is going to register. All those bodies who are interested in the said may report within 5 days. Is it treated to be objection? When we go to the Rule 5E, one copy of the publication in newspaper inviting objection from the general public to the registration of the society. This is total contravention to the Rules E. In such a manner publication, it is not objection, calling objection for registration. So therefore, it's total disregard of the Rule 5E. And others, my lord, let me refer for other condition laid down in the Rule 5. Let me directly refer to the left right, which my learned friend, yes, my lord, page piano. What is the page? Huh?
No, what this court is asking
My lord,
is once an objection is filed,
my lord.
what is the next procedure?
Objection is filed, my lord. Objection, my lord. What? Yes, my lord. Objection, my lord.
In the rules,
Rules,
after objection is filed,
my lord.
what happens?
My lord, if there be any, if they find out the nearly resemblance and the, my lord, identical name, then in that case, section 10 could have been applied. But they are saying that through bona fide mistake, they have not done it. But in fact, my lord, we have filed objection well before registration of the Manipur Hockey. So therefore, their answer is that through bona fide mistake, they have not looked into the detailed documents. So therefore, my lord, left and right, which my learned friend submitted before lordship is that, my lord. Please, piano. Lordship section 10 into come into play only with, on identical name and the nearly resemblance. Why nearly resemblance is not in respect of the Hockey Manipur. Nearly resemblance and identical name is earlier registration, two bodies, 1976 registration, Manipur Hockey Association and Manipur Women Hockey Association, because the motto and rules regulations are in respect of the hockey discipline only. So therefore, nearly resembles and the identical name. And the Hockey Manipur is the unified body of these two associations. Therefore, the Manipur Hockey registered under Section 7, fresh registration. But Hockey Manipur registered under Section 12, amalgamation.
No, as per the rules,
My lord,
if objection is filed,
my lord.
what is the consequential step?
My lord, objection is filed, my lord, that has to be looked into by the authority.
And then where is the provision? What is,
Oh,
and
that
what,
is-
what has been done to that?
Oh, yes, my lord. After objection, my lord.
Yes. Rule doesn't say anything of that.
Yes, my lord.
It's only to a copy of the publication,
My lord.
writing objection.
Yes, my lord. Rule doesn't say.
If objection is filed,
Yes.
if there is any objection,
My lord, I file objection, my lord. From my
Yes.
side, I file objection.
thereafter what is to be done?
My lord, that is in fact silent.
That is, my lord,
Yes, my lord, your lordship is pertinent question. Objection filed, then in that case, the rule, 10, section 10 come into play below. If there be objection, then if there be any identical or nearly resemblance is there, then in that case, section 10 come into play. That is my contention before lordship. So therefore, learned judge, my lord, learned single judge, my lord. If there be nearly resemblance, my lord, two bodies in 1976 bodies, and the Hockey Manipur is the unified body of the two bodies. So therefore, earlier body, my lord, when it was cancelled, that was cancelled on 21st January 2010. And the registration of the Manipur Hockey was 12/1/2009. Page 109. Lordship. It has been reflected in the judgment.
Just one.
2 million. It is, my lord, to my understanding, my lord, it is purely question of law. Participation of international games or protection of the good player and recognition of the MOA or Indian Olympic Association. These are the apart from the issue. Issue is that purely question of law. Right. Yeah, you've not been. Yes, my lord. It can come again into play, my lord. So therefore, my lord, the very important point is 21st January 2010, my lord. Then your lordship pays 108 and 109, my lord, of memo appeal, my lord. How the learned single judge before the single court, my lord. It is clearly reflected these two. One is registration certificate 108 and 109. The certificate issued in respect of the Hockey Manipur, whom I represent before your lordship. Earlier, Manipur Women Hockey Association register number 9476 and Manipur Hockey Association 2002 and 1976 have been amalgamated into one society in the name of the Hockey Manipur. Now, it was on 21st January 2010. Now, on the same day, my lord, these two association registration was cancelled, meaning thereby, next page 109. Consequent on the amalgamation of the Manipur Women Hockey Association register number so and so, Manipur Hockey Association so and so, under section 12 of the Manipur Society registration in 1989, forming a new association in the name of the Hockey Manipur Kumalampak Imphal, to which registration number so and so has been allotted. Now, as I earlier allotted money is the registration and ours is allotted. Series so-and-so register so-and-so, section 12B of the Manipur Society Registration 1990, read with rule 15.8 of the Manipur Society Registration, do hereby cancel, meaning thereby these two associations was non-exist only on 21 January 2010. So therefore, Manipur Hockey was registered on 12/1/2009, well ahead of the cancellation of these two associations, meaning thereby these two associations were very much exist while registering the Manipur Hockey. Therefore, section 10 come into play. Nearly resemblance and identical name. To my understanding, this is for your lordship contention, consideration. This very fact has been clearly reflected. Only two associations were cancelled on 21st January 2010. So at the time of the registration of the Manipur Hockey that was on 12/1/2009, the very existence of two associations nearly resemblance and identical names were there. Therefore, section 10 come into play. So only on this count, my lord, instead of cancelling their registration Manipur Hockey, my lord, it is very fortunate on the part of the appellant to directing to them to amend the rules and change the name. It is very fortunate instead of cancellation. And then, my lord, page 285. Page 285. This is a left or right. Now, my lord, as your lordship is rightly asked on me that under what after the objection was filed, was there any or is there any proceeding to be followed? Now here, my lord, let me refer to 286. Only 5 days were given after the advertisement for registration of Manipur Hockey before the, I am reading right side, was done in violation of the section 13 of the MSR Act 2004. Further, their notification was objected by the secretary. Just I have read it before, lordship. 13 October 2009. And on 16 November 2009 also, twice I have furnished copy to, not to register the Manipur Hockey, well ahead of the registration being issued on 12 November 2009. Accordingly, the principal secretary also deregistered Manipur Hockey, so and so, so. These are the procedure, wrong procedure while registering the Manipur Hockey. And the notification or publication is newspaper is not polling objection. So even, my lord, registration of the Manipur Hockey, my lord, there is total irregularities, or I could say that illegalities in registering the Manipur Hockey. As far as this left right findings of the authority is concerned, pursuant to the interim order passed by the learned judge. And another point is that, my lord, the so-called impugn order 22, 22/1/2018, which has been challenged by them, my lord, was issued pursuant to the order passed by the learned judge, stating that you go ahead strictly as per law. So these are the, my lord, to my understanding, my lord, I am trying to convince your lordship as much as I can. So therefore, these are the contentions and points submitting by me to your lordship in order to dismiss the writ appeal, is because this is total, absolutely the question of law. And learned judge pass order very precisely and on the basis of the factual placed before him. This very fact, which subsequently filed the additional affidavit, was never been placed before the court. To that regard, my lord, I have submitted a batteries of judgment, which your lordship, I suppose your lordship must be having, and your lordship knows better than us. So therefore, ultimately, my lord, I would submit before your lordship that this writ appeal is not maintainable. It should be dismissed. Deeply obliged.
May I please, your lordship. Your lordship has a single bench matter also, my lord. If I take more than half an hour, is it possible to carry on after lunch also? Otherwise, my lord.
After lunch, we are sitting single, no?
Then, my lord, my humble submission, my lord, it may be inconvenient to this honorable court and to my other friend. Because, I may take more than half an hour, my lord. So, my lord, because of replying, giving my rejoinder in piecemeal, just give me a short date so that I can finish it on the whole day, my whole rejoinder in one day, your lordship. I'm just praying, even though there is a
You can't finish in 30
my lord, there are lots of allegations against me by new things they have submitted today. I need a, my lord, the proper.
Will
my
not
lord.
go into all those allegations.
No, my lord, I have to, my lordship.
It's a
But I have to satisfy a lordship.
rejoinder only.
Because, my lord, I have to satisfy a lordship, my lord. Otherwise, my lord, I know that your lordship will definitely give justice. I understand, my lord. But to satisfy myself, my client, my lord, otherwise, I think, yeah, I'll be doing injustice to my client, your lordship, too. I don't expect.
When are you coming back? After 2 weeks. On 19th.
Any sort that, your lordship, any sort that. in this month also.
No, this month, that is possible. The only thing is that my brother is
Hmm.
available only till tomorrow.
No.
So after that, he will be available after 2 weeks.
Hmm.
So we can fix a date after 2 weeks.
2 weeks and first day when my lordship is available in this my lord, anytime my lord. And otherwise, my lord, with great inconvenience we came because my client they cannot afford sending us here.
But then why are we making?
But my lord, but still, my lord, we have to.
Why are we making?
We have to, my lord. Otherwise, my lord, we doing a pro bono basis, your lordship, because of this. In the interest of hockey,
Sometimes,
in the interest of hockey, your lordship.
we are required very, I mean, very sincere solution
yeah.
and a very honest.
And my lord, as a
Very
personal
quiet.
experience, my lord, his personal experience, I mixed up with my lord, done lots of things regarding hockey in Manipur, my lord, as a student time also. So I didn't do pro bono.
Right, Mr. S. Biswajit.
Hmm.
Learned Senior Counsel. Assisted by Mr. A. Kalita. A. Kalita, Learned Counsel for the applicants. Also heard Mr. Adhogo Taylor. Learned Additional Governor Advocate for the state respondents. And Mr. M. Chandra, Learned Senior Counsel, assisted by Mr. Junu Raman. Learned Counsel. For the for the
For the, my lord, to respond, try to respond.
no, how many respondents are here?
My lord,
Three respondents.
my lord, senior, Shaiwala name also be reflected. Even before me.
We also heard Mr. J. N. Chaiwala.
Yes,
the
ma'am.
Senior Counsel, along with Mr. M. Chandra. Then the Senior Counsel assisted by Mr. J. Raman, Learned Counsel for the response number 3. 13 part is for further hearing on. We are available from 19. No?
Sunday.
We'll have it on 20. We'll have it on 28. 23rd, I'm going home. So. 28.
28th of this month, your lordship. Yes. Develop rights, only for Arizona. Do it. Develop rights.
They can bring written submissions also, no? Or so, Biswajit, who is Hem Chandra also? Yes. As a general. You can bring your written arguments also.
Yes, your lordship. Yes. So after completion of my region, I will file it. Develop rights.
Written submission, man.
You can submit on the day.
Fine.
Item 3,
My lord, at the very outset, I'd like to say that I don't want to bother your lordships to make the same argument again and again. Instead, my lord, if your lordship, subject to your lordship's approval, I may file a written argument within 2 weeks. My lord, I think that is better. Because I argued so many times on the same facts.
Okay.
So, my lord, your lordships know about the matter. So I think written argument will be suffice.
Google.
regarding I am not last I have lordship placed two judgment our high court. It was missed in earlier occasion lordship. One is honorable division bench and one is honorable single bench regarding MP part lordship. It was already decided by our high court division bench. That was missing in that relevant point of time.
And my lord, This case is covered by your lordship's Justice Sete very recently, my lord. I'll furnishing this judgment. Squarely on this point, my lord. Justice Sete is aware of that.
One is by the Honorable Division Bench Lordship, authored by my Lord Justice H. Roy, and another one is Lordship by my Lord Justice U.K. Naidu.
Paragraphs?
Lordship, in single bench judgment, Lordship, it's paragraph 13 onwards, Lordship.
Okay.
Paragraph 13 onwards. And division bench judgment, Lordships, it's division bench judgment, Lordship, from the very beginning to Lordship, that everything was discussed by division bench. Lordship. And regarding OM and other things, Lordship, that single bench judgment or division bench judgment also discussed exactly same point. Lord.
Point decided is very short and it has been answered in this judgment.
Oh, yes. Yeah. Yes. Mr. Datta,
My lord,
if you are relying on this judgment,
my lord.
can you take up the matter?
No, no, that's a different issue, my lord. Because is not in appeal. This judgment is, my lord, clarified the position of law. So it's not in appeal that his lordship is again inquiring that. It is not that kind of thing. Otherwise, I would not have placed that. Because this the position law has been clarified.
When do you want?
Just 2 weeks time, because after 2 weeks, Justice Seth will be here
On the same day?
on the same day.
Only please make the mistakes. You can't even senior counsel for that. List of 28.
Much of it.
You also filed the written submission. It's
There was only one point I have already submitted. I'll do.
You, you.
I'll do. I'll do. I'll do.
So I may be well, allowed to do this matter in the tomorrow's cause list, man.
Please, Lordship, I beg to mention item number 13. We have sent a letter to the client but not able to receive any response from their side. So kindly the matter may be fixed after 3 weeks.
13.
Yes,
Your good name?
A Parasar,
You are appearing on behalf of,
Ardhar.
on request made on behalf of Ardha. General counsel for the petitioner. List up to 3 weeks.
Highly appreciated.
I want to mention item number 14.
Yes,
Your senior is not present today. Let the matter be listed after 1 week.
who's your senior?
Sharan Deka.
Huh?
Sharan Deka.
C. Dega.
C Deka.
On request made on behalf of C. Dega, then the counsel for petition. When do you want?
After 1 week.
List up to 1 week.
May I please, your lordship? Lordship, I'd like to mention for listing of a petition lordship on tomorrow lordship. Similar nature of the cases are listed on tomorrow lordship.
Oh.
So I'm praying for listing on tomorrow lordship. This case. It was filed on 4th of April lordship.
Let it come up in its usual time. It's a fresh filing, isn't it?
Lordship.
It will come, take up on Monday.
Obliged lordship.
Items 1 and 2 of daily list, motion.
May I please, your lordship? Lordship, in item number 1, my learned friend has filed an affidavit in opposition. Lordship, however, in this matter, formal notice has not been issued. Therefore, the department's affidavit and all are not on, they have not filed it. At this stage, I prefer a notice, that let them file their replies.
Item one.
Item one.
What about item two?
Item two,
Item
Lord-
two, I am the petitioner,
I'm the-
my lord, I'll submit. After my learned friend finishes in item one, I'll submit.
Lordship, and in item two, we have been arraigned as a respondent, therein we will file our affidavit in opposition. Lordship. In item one, Lordship, notice is yet to be issued.
Okay, but Mr.
A Chakraborty. Lordship.
A. Chakravarti, learned counsel for the petition. Issue notice. Elementary education, education department. When there's nobody present today, what can we do?
My lord, may issue notice, they will serve serve extra copies otherwise, so.
Mr. SMT Chisti, learned standing counsel, school education department, appears for respondents,
2 and 3, Lordship. 2, 3, and 5 probably.
1, 2, and 3.
5 as well, Lordship.
1, 2,
Inspector.
3, 5. 1, 2, 3, and 5. And respondent for administrative officer, free regulatory committee.
Lordship, 4 also, I think, school education can appear because the committee is formed by the Department of School Education.
This is the problem when they are not present. Oh, how?
I understand, Lordship.
Okay, we'll take up at 2 o'clock. Yes. You called them.
Lordship, oblige.
My lord, both items, item two.
Item 3, admission, part of matter.
May I please, Your Lordship?
Hmm.
For refreshing very briefly, my lord, I'd like to apprise, my lord, the petitioner before your lordship is a widow of a bank manager who was working as a branch manager in Gorukuti, my lord, and he was placed under suspension, my lord. Thereafter, he has submitted his reply, my lord. Thereafter, my lord, an inquiry was caused, my lord, by the departmental authority, my lord. But inquiry report seems, my lord, it is one-sided, my lord, that I'm coming, my lord. Then, my lord, we have, he has been dismissed from the service, my lord. Thereafter, my lord, we preferred an appeal, my lord, but the authority, my lord, informed us, my lord, the appellate authority has said, my lord, the first order, dismissal order was logical, my lord, but there is no such order, my lord, of his own motion. First, lordship, I like to draw lordship's attention that page 36, my lord, I was placed under suspension.
Yes.
Whereas the disciplinary proceeding contemplated against Mukut Sharma is my husband, my lord. Assistant so-and-so Gram Nalbari and so-and-so gross misconduct to have been committed by you, the bank at Gorukuti branch in his tenure, and considering the seriousness and gravity of the alleged misconduct, undersigned hereby place Mukut Chandra Sharma, Assistant Manager, Assam Gramin Vikas Branch, Nalbari branch, suspension with immediate effect pending withdrawal of the departmental proceeding. During the period so-and-so was then. Thereafter, my lord, I have been asked to submit a show cause, my lord, that your lordship will see at page 37.
Yes. Then
It is alleged, my lord, the tenure of the service so-and-so 16 number 217 numbers of self-help group with a period of 16 months. That is from 2716 to 27 altogether, an amount of 4.15 lakhs 20,000 was sanctioned against 217 number of, while sanctioning this, you had committed gross serious irregularities. So, my lord, a series of show cause have been served upon me, my lord. And the part of the show cause, my lord, the relevant portion lordship will see at page 41, serial number 9. The transaction recovery status of the loans are poor. Just 9, my lord, at page 41. Transaction recovery status of the loan as very poor, negligible. There is an outstanding balance of self-help group as on 21/6/19, as your sanction amount of 14-15 loan are going to early mortality category. There the facts reveals that the recklessly you have exercised discretionary power cause financial loss to the bank, my lord. Then lordship kindly turn to page 42. In view of the above, you are advised to explain the conduct of the serious irregularities committed by you during the tenure of the service branch manager, Gorukhuti branch. Please show cause the disciplinary proceeding will not be initiated against you for committal these irregularities and to reply should reach the undersigned within 15 days. Thereafter, my lord, page 43, I have replied to my show cause, my lord.
Yes.
Show cause, my lord, some for a gallons, my lordship will see page 45. I'm skipping other things, my lord. Inner paragraph 4, 5, my lord. That the statement made in your so and so self-help group mentioned in the list not formed during my tenure in the Gorokhuti branch. I further respectfully beg to state that it is not my duty to check out the person has joined the multiple self-help groups as the members will known. Then next para 5, my lord, that that as to the statement made in para 4 of your, I humbly beg to state you that it is not my duty to scrutinize the sanctioning loan of self-help group, whether self-help group interlend money or not. It is not my concern. It's self-drawn checks issued by self-help group and transferred to save help saving account of some other individual self-help group. It is further back to state to the I am totally not aware of the withdrawal slip treated as a transport voucher and huge amount of different saving account of self-group were transferred to saving account to the individuals and withdrawal slips were collected as alleged in your letter because it is not under my duty to check and supervise when any office bearer of any self-help group withdraws or transfers money from saving account. It is pertinent to mention here that the out of bank and cause of in case of non-availability of the checkbook's branch withdrawal slip can be used and treated as a transport voucher of the money. So, my lord, my
So
lord,
you get your reply.
I made in my reply, my lord, and some portion lordship will see for a page 47, my lord. Only era 11 lordship will see, my lord. It is the statement made in 5F of your letter. I beg to state that Dulul and Dulal Haq are two different persons. Moreover, I beg to state that no fake voter ID was accepted by me from any person sanctioning any self-help group as per my knowledge. It is further beg to state that a fictitious loan was created and disbursed without any ulterior motive, and as such, the bank is nowhere defrauded me. It is pertinent to mention here that it is not true that there is no recovery except recovering portion of saving account bank has exposed to incur financial loss of 2.279 being the outstanding amount of the. So altogether, my lord, I have replied, my lord. Thereafter, my lord, what happened? And letter was issued to me as page 51. 51, my lord. Holding that, my lord, my reply was not satisfactory, my lord. So they need to go for inquiry, my lord. Thereafter, my lord, article of charges was issued, my lord. Written argument is a then lordship will see page 52. Then, my lord, the lordship kindly note down, my lord, the rule 39.1B of Assam Gramin that on the last occasion, I have given that law book, my lord, maybe in the record, my lord. They made in, my lord, proposal made a 39(1)(b) of the Assam Gramin because for article of charges was issued to me, my lord. But last part at page 60 of that article of charges, my lord, last paragraph, lordship, is important. Page 60. It is a continuation of article of charges, my lord. Page 60. Having done so, you are grossly violated the regulation 12 and 20. Lordship, kindly note down, my lord, 3 provision, my lord, 39(1)(b) and 18 and 20. From the book I have already marked, my lord. You have violated Assam Gramin Bank Officer Employee Service Amendment Rules 18 attracts the penalties 31(9)(1)(b) of the service regulation. I was been inquiry was conducted, my lord, basing on 18 and 20, my lord, and penalty provision was provided 39(1)(b). Thereafter, my lord, I have been asked to give, my lord, then accordingly, my lord, I have given my reply. So, written statement, my lord, on the article of charges that your lordship will see annexure 6, page 61 onwards. And operative part of my reply, lordship will see page 69, last page, which is needed for adjudication of the instant case, my lord. The bank prior to the alleged incident,
Page
69, my lord, is the continuation of my reply, my lord. Page 69, the bank prior to this, the alleged incident, it is no point of time any such allegation ever arose against me. Sir, in replying to your letter, I respectfully beg to submit that neither any such irregularities were committed by me, nor I have violated the regulation 18 and 20. Assam Gramin Vikas Bank during my tenure service of the branch manager at Gorukuti branch as charged against me in your letter dated so and so. I humbly request you not to initiate the inquiry against me under regulation 39(1)(b) of the Assam Gramin Vikas Bank officers employed, that is the service rule amended. Thereafter, my lord, they not being satisfied, my lord, they have proposed, my lord, at page 70. Page 70, my lord, for departmental inquiry, my lord. 2 persons have been appointed by the bank themselves, my lord. One is Tajinder Singh, is the senior bank manager, inquiry officer. And one person, my lord, Hemkant Jit Bora, is my lord, presenting officer.
yes.
And though they said, my lord, in the page 71, my lord, that defense will be given to you and you will get all the ample opportunity. But nothing happened, my lord. There, my lord, the inquiry report was submitted, my lord, page 72 onwards, my lord. And presenting officer, my lord, he has produced the relevant documents, my lord.
This is the inquiry report.
Yes, my lord, page 72 onwards, my lord. And exactly at what the operative portion, my lord, inquiry report, what he said, my lord, that your lordship come to page 84. The outcome of the inquiry report. It is provided that irregular disbursement were made by transferring amount of loan granted to the self-help group unauthorized manner to accounts of Javed mandated so and so Iqbal, who were not members of the self, violating the self-help group norms, and this has been the illicit transfer and fund, exposing the bank to inner financial loss and also putting reputation of the bank stake. During the inquiry, CS, the charge officer, was not able to defend. It is the wrong, my lord. My lordship will see, he has, in the inquiry report, nowhere he has mentioned, my lord, his version was only recorded one-sided, my lord. Not able to defend himself against any charges level against him, nor he was able to produce any documentary evidence in the support. All the charges leveled against him, bank by letter dated, has been established. Thereafter, my lord, what happened? I have page 85. I have submitted my written argument, my lord, and I have categorically stated that the relevant documents was not given to me, my lord. Lordship, kindly have a look at page 89, my lord. As per, page 89, lordship, is the part of, my lord, my written argument, my lord. Moreover, as per the lordship 89 page. Some is the long one, but I'm reading only relevant portion, my lord. Moreover, as per the procedure of the bank, it is the duty of the credit officer. There is, my lord, two things, my lord. Lordship will see. One credit officer, he has to verify, scrutiny, everything, my lord. Then finally it goes to the bank manager for necessary approval or whatsoever it is needed for causing, my lord, any loan to any individual or self-help group, my lord. Moreover, as per the procedure of the bank, it is the duty of the credit officer of the bank to receive the loan application as well as to check the and verify the loan applications along with the relevant documents as required. Accordingly, all the documents furnished with the said loan applications were checked and verified by credit officer of Gorakhpudi branch, and thereafter the credit officer puts his signature in his column of the loan application and submitted the applications before me, meaning thereby loss. We'll continue at 2.
One and two. In item one, you take down. But Mr.
A Chakraborty.
A. Chakraborty, Leonard Council. Issue notice. MS
PDAS,
Vidas, London Standing Council,
secondary education.
Secondary Education appears for respondent.
Respondent.
Elementary also.
No, your lordship, I am appearing for respondent number 3, secondary director of secondary education, and respondent number 5, the inspector of school city.
What about 1 and 2?
1 and 2, my lord.
State of Assam.
State of Assam and Mr.
No, 1 and 2 is elementary.
Elementary, Satyavati.
Chisti. Mr. Chisti was there.
Then you give
SMT 60.
Mr. SMT Chisti. Then Standing Council Elementary Education appears for respondent 1 and 2. MS Vidas, London Standing Council Secondary Education for respondents 3 and 5.
3 and 5.
3 and 5.
Kindly extra copy may serve.
Okay. Then rest you have to take steps.
My lord, I am appearing for respondents number 8 and 9.
6 and 7.
And Mr.
D Chakraborty for 8 and 9.
D Chakraborty. D Chakraborty, Leonard Council. Appears for respondents 8 and 9.
4, 6 and 7 will take steps. Lordship.
Petitioner to take steps for service of notice on respond number 4,
6 and 7.
6 and 7 by registered proceeding within 1 week. So extra copies will furnish to
Gotcha.
the Leonard Council appearing to the respondents. This the matter, respondents are allowed to file their affidavit. This Dr. 4 weeks.
4 weeks.
My lord, respondent number 8 and 9 already has filed an affidavit in opposition pursuant to permission given by this honorable court.
Okay. That will be.
Lordship.
That is already there.
And what is item 2?
In item 2, notice was already issued way back on 9/6 to 2023. There is a office note, my lord, in regard to service upon respondent number 4. Pursuant to fresh steps taken, the notice only has been dispatched on 9/4. So today not being a month completed, I think service report can be awaited on respondent number 4. Others are served, others are appearing.
When was it dispatched?
9/4 is the office note, your lordship will see, 9/4. There's the office note dated 9/4/2024.
Service reports are waiting.
Okay, then let it come up along with this.
Yes, along with it.
Heard Mr.
D Chakraborty.
D Chakraborty, Leonard Council petition. Await service report on the respond number 4.
Yes, my lord.
And list the matter after 4 weeks.
They are appearing for the respondent. Obliged.
Obliged.
Here.
Yes,
My lord, we were last before first of my lord at page 89. Immediately after the inquiry, my lord, we have replied, my lord.
yes.
So operative part 3, paragraph 3 at page 89, I have already read, my lord. Now, my lord, paragraph 4 at page 89. That as the charge number 3 made in the brief argument, I have submitted the manager presenting and presenting officer. I argue that I have already stated in my detailed written statement that the said self-help group mentioned in the last date did not form during my tenure in the Gorkuti branch. It is not proved during the departmental proceeding that during my tenure all the Gorkuti branch said group mentioned in the list were formed. Neither the evidence of management witness, MW is the management, my lord, management witness, nor any documentary evidence states that the aforesaid self-help group were performed during my tenure at Gorukuti branch. As such, I am not totally liable for any if some person has become the members of more than one group during our office tenure, my lord. Then lordship will see next page, page 90, my lord, that the charge number 4, I argue that it is not my duty to scrutiny after sanctioning the loan to any self-help group if the said level interlent the money. It is not my concern in the self-drawn itself. The checks is issued by self-help group were transferred to saving account of other individual self-help group. As such, it is not proof that I have violated the bank's norm. Further, I beg to state that I am totally not aware of the withdrawal slip were treated as a transfer voucher and huge amount from different saving bank account of the self-help group were transferred to saving bank account for few individuals and withdrawal slip were collected as alleged as because it is not under my duty to check the and supervise if any office bearer of any self-help group withdraws and transfer money from the saving account. That is the, my lord. I have totally denied, my lord. Is a big reply, my lord. Last page, lordship will see at page 98, my lord. Before that, my lord, lordship kindly have a look at page 97, paragraph 11. I humbly submit before you, sir, that I have not done anything violating the bank's norm as alleged against me. It was also not proved that there was any ulterior motive from my side in sanctioning the loan as well as disbursing the loan amount to the self-help group or to any individual. None of the charges framed against me were proved during the departmental proceeding. Therefore, I pray for discharge from that. Thereafter, my lord, page 98, my lord, I have made my reply, my lord, concluding part. Ingredients were committed by me and I have violated regulation 18 and 19 of Assam Gramin Vikas Bank during the death. The tenure of my service in Gorukhoti branch charged against me as I humbly pray your discharge me from the charge. I have categorically stated, my lord, paragraph their provision of 18 and 20 because inquiry was conducted basing on this 2 points. Thereafter, my lord, next page, annexure 11, my lord. Annexure 11, my lord, some documents were not furnished upon me during inquiry period, my lord, and I was not also been allowed to cross-examine. In the absence of document, my lord, I cannot. Then, my lord, I have written to them, my lord, the inquiry officer, my lord, starts from subject, my lord. Prayer for supplying the copies of the document bearing serial number 456 in management evidence 3 stated the witness, if any, date 10/11. So with due respect, I beg to state that I am the charge sheeted officers in the departmental inquiry by charge number so and so. That sir, on 28/2/20, I was present in the aforesaid departmental inquiry. Honorable inquiry officer
in the above mentioned departmental inquiry was pleased to pass the following orders. Defense side is allowed to, Lordship kindly mark this point, my lord. Defense persons allowed to 15 days time from the date to verify the documents as listed in ME2 in original. PO is presiding officer is directed to arrange the verification of the documents with the listed documents with the stipulated period and receipt of the defense side of doing so and submit the same to the inquiry officer. The defense side is advised 15 days time to defense the documents and witness and required for the purpose of the defense. Then Lordship will see page 100 is the continuation, my lord. That's you were pleased to fix the departmental inquiry on 18/3/20. That's most respectfully, I beg to state before you that I have already received the list of documents and list of witnesses yet. But the copies of the document, more specifically documents bearing number 4, 5, 6, 7 and ME5 statement of witness have not been served upon me till date. That, sir, I humbly request you that I have decided to defend myself departmental inquiry without engaging any other defense representative, but I could not able to collect the contents of the documents exactly, more particularly document number 4, 5, 6, 7 and ME3. As such, I pray you to, sir, to allow me to defend myself, because, my lord, that person, my lord, the presenting officer, he did not listen to me, my lord. He is as if he is acting on behalf of the management, my lord. Lordship will see the from inquiry report. Nothing has said, my lord, about cross-examination, whether you want to file your cross or any other thing. It has not been asked, my lord. As such, I pray your sir to allow me to defend myself aforesaid departmental inquiry, and also pray you to supply the copies of the document number so and so to and statement of the witness as early as possible, so that I can prepare for hearing to be held on 18/3/20. Because this till before that, my lord, I have not been supplied with the documents for which I asked. Thereafter, again, my lord, in official capacity, I have approached to the authority for supplying the certified copy at page 101. Lordship has come across annexure 12. Charge, there is a 5 reference documents, my lord, earlier correspondence so and so. Then I beg to submit you that regarding the subjects that I have already made one correspondence addressed to you by the letter above reference number 5, which is the self-explanatory. Your ready reference same is enclosed herewith for. Despite of my request by letter as well as the last equally inquiries sitting on 18/3, yet I have not received a single copy of the document. Request you to record the side of the correspondence in the last proceeding, but it was ignored and not recorded. Because he is their people, my lord, he has acted on behalf of them only. That, sir, I once again humbly request you to provide and furnish me the certified copies of all the papers relating to all documents listed as per the above mentioned and letters so and so early possible. Further, I request you to give me at least 15 days time from the date of handover all the documents prayed for, and to verify and scrutiny my proper defense in the further proceeding and sitting. I am surprised, despite of respected request in the inquiry proceeding held on 13/3/14/5, the correspondence dated so and so have not recorded. Sir, I present a letter to you requesting to hand over the certified copies of the document, which have been received duly and acknowledged, my lord, by putting their signature, my lord. Though I have put, my lord, signature 13/5/20, my lord, that has not been given. Thereafter, my lord, finding no alternative, my lord, I was compelled to give my written argument. And lordship, at page 105, para 3, I have categorically stated, my lord, that you did not submit the document. May I read, my lord, para 3 of my reply? That, my lord, written submission. Immediately after, my lord, inquiry report was submitted. I'm reading, my lord, para 3 at page 105. That the finding of the charge number 1 seated inquiry report number so and so, I beg to submit that you, sir, I deny the same group photo was attached with the loan documents for different self-help group for different members. I further deny any fictitious loans were created by me. It is pertinent to mention here that the group photographs attached with the loan documents ME number so and so were never exhibited in the departmental proceeding to prove these photographs. Thereafter, my lord, I have already stated in several time also in the written argument also that you have not supplied the documents. The operative part of that written submission, my lord, lordship will see at page 113. Middle portion, my lord. I further beg to state that no fictitious loan was created and disbursed by me with any ulterior motive. As such, the bank is no way frauded by me. It is pertinent to mention here that it is not true that the recovery except the remaining portion of the loan saving account opposed the financial loss of 2.2 crore 2 lakhs 700. No, my lord, 2,02,794 being outstanding amount in the account list. Rather is the true fact the self-help group were paying monthly installment in their loans regularly as per my knowledge. It was neither proof Kushal Kumar so and so the fake one was sanctioned to the self-help group fictitiously. It is also not proof. So accordingly, I denied all the things, my lord. It is a big, my lord, whole day it will take. Anyway, my lord, I'm for making short, my lord, I have denied. Thereafter, my lord, page 121, after my submission of the written argument, my lord, then the impugn order has been passed. At page 121, dated 7/9/20. Departmental inquiry was held to inquire into the charges framed against you in the bank's letter charge number so and so, observing the principle of natural justice. My lord, now he has added extra mode. Principle of natural justice, reasonable opportunity were given to you and side so and so taking the proper defense and you participated in the inquiry. I have carefully perused the records and day-to-day proceeding evidence attached to the both side and finding of the inquiry officer so and so submission thereon. I concur with the findings of the inquiry officer and satisfied that the evidence recorded at the inquiry have come to the conclusion that all the charges have been leveled against you have been proved and established beyond doubt. After considering the facts and circumstances of the case and gravity of the proved misconduct, your records impose so and so under the major penalty of 39(1)(b) of the Assam Grameen Vikas Bank Amendment Service Rule 2018. Thereafter, my lord, within the statutory period, my lord, I have filed my appeal at page 122. I have taken same plea, my lord. Necessary documents were not given to me. Then, my lord, they have said silently, my lord, they have not been. Page 122.
Appeal.
122. Annexure 15, dated 19/10/20.
Yes.
That I have filed my appeal, my lord. They have not come to the conclusion, my lord, what happened to my, in the meantime, my lord.
So what penalty was imposed?
Penalty, my lord, they have said, my lord, 39(b) major. But it seems, my lord, I have been removed. That I'm coming, my lord. Now, lordship, during pendency of that appeal, my lord, I has died, my lord, at 135. That is the death certificate.
Which?
135. Date of that is 8/7/21. I died of accident, my lord. Thereafter, my lord, they did not come up with the findings, my lord. Then, my lord, I, on behalf of my client, the widow of the bank manager, issued a legal notice on 18/6/21. After 18/6/21, my lord, they have communicated a letter that your lordship will see, page 138. This is also impugned. But it is, my lord, incorrect position have been given. That I am coming. Last page, my lord, 138. Appeal petition of late Mukut Sharma, review of the punishment, has reference under the mention. It is the regard to the perform that the appeal petition so and so number before the chairman appellate authority of the bank review the punishment of the general manager disciplinary authority so and so. Accordingly, after careful perusing of the records, inquiry evidence and adduce the considering the he has written of his own mind because it is contradictory, my lord, with the appeal order. Facts and circumstances of the chairman appellate authority bank has disposed of the appeal of late Mukur's upholding the decision of the authority, finding the same as impartial and appropriate. This is for your information. That, my lord, he has no authority to say, my lord. Then, my lord, during pendency of the case, my lord, while the hearing was going on, my lord,
No, appeal was disposed of by the appellate authority. That is what you have been informed.
informed. But what, my lord, he added line, my lord, decision of the general authority are the same as impartial and appropriate. This is, he has added, my lord. Now, lordship will take up, my lord, my additional affidavit, my lord, which I have filed on 22/12/23. Lordship come to page 143. That has been supplied by my learned senior friend during course of the hearing, man, on that day. That is the appeal order, my lord. This is the Mukut Sharma so and so, and lordship kindly turn to page 144.
Yes.
Last line, my lord. All these things are facts, my lord. Placed before the chairman appellate authority for kind perusal and necessary action and necessary advice. This much, my lord. Now, my lord, the learned counsel for the other side wants to rely that, my lord, page 143. Lordship kindly turn back to page 143. Just previous page, my lord. There, lordship will see decision of DA, meaning the departmental authority, is logical appeal not to be considered. Only this much. But from where, my lord, he got the word, my lord, decision of the general manager and authority, the finding the same is impartial and inappropriate. Page 138, my lord. Lordship just make a compare, my lord. Page 143 and 144 and page 138. He said, my lord, decision of the general manager and disciplinary authority of the bank finding the same as impartial and appropriate. But matter was placed before only appellate authority. He has, my lord, written one line. That is not the reason order, my lord. Law requires the reason order. He has, my lord, of his own hand. I don't know, my lord, how it is come. Decision of the DA is logical. Appeal not to be considered. Only one line, man. Not even one line, half line. Lordship has come across page 143. They said it is the appeal. But the authority, my lord, the head of the vigilance, he said the decision of the general manager and authority of the finding are same and impartial. From here he got the word, my lord. Appellate authority never said it is impartial or this thing. They just simply mentioned the facts and placed before the chairman, who is the appellate authority, for kind perusal and necessary advice. This was communicated only, my lord, immediately after receiving of the notice. Now, lordship will see this cannot be a reason order. One line, my lord, nowhere in the lifetime, my lord, I have come across a one-line order. That decision is, if it is taken into face value for the moment, decision of the DA is logical, appeal not to be considered. This cannot be. Appellate authority has to decide, my lord, basing on the merits. And there, my lord, general manager of his own, my lord, he has communicated it is logical and, my lord, the impartial or inappropriate. It was a total misleading document, my lord, misguided. The widow, my lord, she is finding, my lord, she has to issue legal notice. Then only, my lord, this was communicated. Even though, my lord, they did not say about this order. This was procured, my lord. I have filed my affidavit during course of the hearing, my lord. it was supplied, for which I have to bring it by virtue of law. Now Lordship will examine the law point involved in the case is that, my lord, Lordship will see that I have given a book, my lord, Lordship has come across Assam Gramin Vikas Bank. I have flag marked mine. Lordship will see by virtue of which I was caused an inquiry. That is the rule 18. 18 says, my lord, liability to abide by the regulation and others. Every officer employed shall be conform or to abide by this regulation and shall also observe, comply with, and obey all the orders, directions may from time to time be given to him or any persons under whose jurisdiction superintendence of the control may for the time being be posted. And 20, Lordship will see it is written, my lord, obligation to promote bank's interest. Obligation to promote bank interest. To promote bank interest, every officer or employee shall serve the bank honestly and faithfully and shall use utmost endeavor to promote the interest of the bank and shall show the courtesy and attention of all the transaction dealing with the officers of the government, the banks constituted and customers. Now Lordship will see the penalty provision by virtue of which, my lord, they have not come with the specific penalty, my lord. They have come only, my lord, 39(1)(b). Lordship will see 39. And that dismissal order, Lordship will see at page, my lord, at page 121. That is the impugn. Now, my lord, it is not specified, my lord, what. Lordship, kindly have a look, page 121. After considering facts and circumstances of the gravity of the proved misconduct, past record, I impose you under the noted major penalty items regulation 39.1(b) of the Assam Gramin Vikas Bank's regulation. Now 39(1) what says, my lord? 39 says, my lord, without prejudice to the foregoing regulation of the chapter, an officer or the employee of the committee breach of this regulation who displays the negligence inefficiently, inordinate, so and so, departmental or the interest of the bank and conflict the instruction or commits breach of discipline or guilty of an other acts misconduct shall be liable for any one or more penalties as follows. Number one is not one is the minor penalty, censure, withholding stoppage, withholding promotion, recovery of the annulment, reduction to the lower stage. Then, my lord, B is the major penalty. B also, my lord, assuming for the moment, my lord, page 121. That is the impugn. Major penalty, severe as Roman 5 of A of subsection 1 of the regulation 39. Reduction of the lower stage in the case of the pay and specified the period for further direction whether or not officer shall earn increments pay during the period of such reduction, whether any expiry of such period the reduction shall or shall not have an effect of postponing the future increments. This is the B says, my lord. 1 Roman 2 says reduction of lower grade. Number 3 says compulsory retirement. 4 says removal from the service of the disqualified future employment. 5 dismissal shall ordinarily be disqualification for future employment. Explanation. For this purpose, regulation, the following shall be amount to the penalty, namely withholding one or more increment as an officer on the account of his failure to pass departmental test or examination in accordance. This is the stoppage of, then again explanation, Roman 2, stoppage of increment. Then Roman 3, my lord, not giving officiating assignment, non-promotion of the officer to a higher grade scale. Then, my lord, reserving the posting of the promotion officer for the reasons like completion of certain requirements for the promotion, revision to lower grade, reversion to the previous grade, reversion of censor. Which one to be taken, my lord, as on date, we do not know. 39(1)(b) says, my lord, there is several penalties which I have read out. That has not been. Over and above, my lord, The sole inquiry was conducted basing on rule 18 and 20. 18 says something else, 20 says something else, and penalty was given something else. And what penalty, my lord, yet from the plain reading of this, my lord, nobody can understand. I hope, my lord, this court also could not have understood what penalty I have been imposed. Because there is a various penalties. Which penalty it is not specific. Only simply say 39(1). These, there are several, my lord. It cannot be at a time, my lord, all the punishment have been imposed upon me, whatever mentioned in 1B, that cannot be, my lord. And that too, my lord, lordship has seen, my lord, appellate authority. There is no cause and reason, nothing have been, my lord. And inquiry report also, my lord, they have not supplied me the relevant documents. And version of the inquiry, my lord, lordship will see, my lord, he is working on behalf of only bank. He is a presenting officer. He was not impartial. And nowhere in the inquiry report said, my lord, that you declined to cross-examine or you have not verified the document. He said, my lord, inquiry officer report says what, my lord, lordship, kindly have a look once again, my lord. For random sake, my lord, I'll just check it up, my lord. Page 72 starts, my lord. '72 will do also, my lord, last bottom page. For the sake of argument, my lord, let's see the charge number 1. Hemakanta Ji Bora, the presiding officer, produced material evidence 4, 5, 5B, 5C, 5E. So in the inquiry, the management witness Kunjomani Sinha, branch manager, Gorkoti branch, to prove the charge. Examine number so and so, the original loan documents of Selva Group detailed in the above charge, and after verification of group photographs attached with the amount, he found the background of the sitting so and so. MW1 also examine materials management evidence number 4. The attendance of the register of the Gorkuchi branch compared with the statute of the charge officer signature presented the attached ME number so and so up to, my lord, ME number 6. Thus it is proved. Lordship, just see the language, my lord. Thus it is proved apparently same looking photograph having identical background of sitting, fabricated different dates of the member accepted the attachment of these documents so and so. Now again he said, my lord, thus below the page 73, below the table graph, my lord, so and so Bora, the presiding officer, produced document number so and so, management witness number 1 so and so, same group. Now, my lord, lordship will see page 74 of his findings on nothing has been written, my lord. Thus it is proof. Group photographs accepted, loan document, though the last different group names, group members and fictitious numbers so and so. He said, my lord, this number similarly with the charge number 2 and 3 and other charges also, my lord, lordship will see for the random sake. I have checked out 1, my lord, and conclusion he has come, my lord, at page 84. During the inquiry, the charge officer was not able to defend himself against any of the charges level against him, nor he was able to produce any documentary evidence in his support. So where is the, my lord, that thing that I tried to project something or he declined to allow me for cross-examination? Nothing is mentioned. Inquiry report is not sanctioned. Prima facie, it is seen, my lord, it is a bias inquiry report because the presiding officer, he himself, my lord, acting on behalf of only bank, not impartial. He did not even ask. I have written to him also, to the authority also, supply me certain documents. They have not supplied. Ultimately, it resulted to a impin order. Impin order dismissal or what, my lord, only 39(1) they have issued. What exactly the mean, my lord, because of which they have never preferred to file affidavit. As on date, my lord, they declined to file affidavit. They said, my lord, lordship will see the orders. They said will rely upon the records of the bank. There is a specific contention I have taken out. that you did not supply this document, that document, it is impartial, bias, and they have not preferred to file any of it. Rather, they come up with this is the third day of hearing most probably, before your lordship, they have come with the record. They did not feel necessary to file, rather they declined to file affidavit, order will reveal, my lord. Thereafter, my lord, they said, my lord, it is proved. How it is proved, my lord? For the face value of the inquiry, any order has been passed against me, my lord, my question of livelihood is concerned. They have not mentioned anywhere in the inquiry that these documents you proved it is not relevant or not acceptable, nothing as such. He mentioned the version of the management witness, these documents A to B, Z document, and he came to the finding of the conclusion. Even though, my lord, my case was not considered, I filed an appeal during my lifetime, that was also not considered. Accordingly, my lord, I have to issue a legal notice. Only after issuance of the legal notice, they replied that the appellate authority has considered and this thing, but nothing is revealed from the order sheet. Appellate authority copy was supplied upon me, which I have annexed in the additional affidavit. That also does not speak about reasonable opportunity. Entire proceeding, my lord, departmental proceeding, process, procedure, everything has vitiated, my lord. The case will go, since I am no more alive, my lord. I'll get only monetary benefit or widow, my lord. I am widow, my lord. I'm surviving with my 2 children. Nothing, my lord. I'll not get job back, my lord. Till, my lord, my service period, my lord, whatever benefit it is there, pension, whatsoever it is, that ought to be provided to me, my. Apart from this, lordship will see that has seen, as on date, my lord, the bank authority is not clear what penalty they have imposed upon me exactly. No specific. Had it been, my lord, the file the affidavit opposition, my lord, the picture would have been clear. And I would have got a chance, opportunity to reply that. But they have miserably failed, my lord. They have declined to file affidavit. Order sheet reflects. So in view of that, my lord, the entire proceeding initiated, my lord, both dismissal order as well as my appellate order does not survive. It vitiated, my lord. The principle of natural justice particularly was deprived of, to me as well as my husband also, late husband. Because time and again, lordship will see, I have annexed all the document with the due acknowledgement, my lord, they did not supply. And my lord, inquiry was conducted for something else, penalty was given on something else. If the inquiry was conducted, my lord, rule 18 and 20 for misconduct, penalty would have not been this thing. But they are not specific, my lord. They are determined to deprive me, my lord, from my legitimate right. So in view of above, my lord, nothing could have been projected by the bank authority, my lord. Why, my lord, dismissal order followed by the impugn appellate order? Appellate order, lordship has seen, nothing has written, my lord. If the bank authority of his own motion has said, my lord, it has been considered, found logically impartial, but appellate authority never said. Single word said, my lord, if it is taken into account, my lord, this is not in accordance with law. Appellate authority has to give reasons. For these particular reasons, your appeal is not accepted or accepted. Because appellate authority also their person, and me also, my lord, I'm bank and I'm the duty bound, my lord. Whatever acted, I have acted, my lord, and I am not, my lord, only. It is the credit officer, my lord, whose responsibility is to check and verify. It does not mean, my lord, somebody else committed wrong, I should be suffered. So in view of that, my lord, impugn order, my lord, has to be set aside along with them, my lord. Further direction to pay me all the monetary benefit as prayed in the writ petition, my lord, which I have prayed in lordship will see page 30. A, my lord, cessary shall not be set aside and quash the impugn termination dismissal order dated so and so, disciplinary authority, a writ in the nature of so and so, and my lord, B, mandamus issued setting aside and quash the impugn order communicated so and so, whereby it has been informed the appeal by the Mukul Chandra Sharma has shown to have been rejected, followed by all the consequential action. A writ in the shall be the respondent authority to drop the entire impugn proceeding so and so, and writ in the nature of matter shall not be issued directing the authority to exonerate the husband of the petitioner from the alleged charge, interfering with the impugn dismissal order, so and so proceeding followed by the impugn communication as well as consequential action original and to reinstate to cannot be, my lord, he died in service with immediate effect, providing all the monetary benefits to the husband of the petitioner to the with effect from his suspension till the date of his reinstatement. Reinstatement cannot be, my lord, because he died.
Yes.
That much, my lord, your lordship has seen, my lord, and lordship will peruse the record, my lord. Lordship will peruse the record, my lord. What prevented the bank authority for not filing affidavit? If it is not filing affidavit, my lord, the meaning thereby it is accepted. My contention of the writ petition is accepted. So my humble submission before your lordship, my lord, lordship will pass the records and lordship will pass the appropriate order in favor of the petitioner. Lordship has time and again has seen, my lord, there is no specific penalty. What penalty I should be? It is not, it is a rather, my lord, vague impugn order. And appellate also, my lord, lordship has seen the no, my lord, reason order as recorded under the law. To that effect, my lord, some judgment is there, my lord. It has been held, my lord, departmental proceeding before and after amendment of 311, my lord, I'll supply to the court, my lord. And that person was alive, my lord, which judgment I'll rely. But question of, my lord, remand back cannot, because he died. So only, my lord, till my death, I am entitled for the benefit. That judgment I'll submit you. And that judgment was originated from relying upon a judgment of the apex court, which I'll supply to your lordship.
Where's the judgment?
Judgment, I got, my lord, one master copy, my lord. I'll get it photocopy, then I'll supply to your lordship. It is Karnataka at Bangalore. That I'll supply, my lord. It was also a respect of the bank. Viswanathan Technology University. That supply I'll have marked, my lord, what are the operative part. And there also, my lord, several judgment of the apex court has been taken into account. That copy I'll supply. It photostat query. I'll supply within half an hour before your lordship rise. So that's all, my lord. It is prima facie seen, my lord. It's vitiated entire proceeding, my lord. Rather, it was established also, my lord. The bias attitude was adopted against me, my lord. From the record itself reveals, my lord. Even for the inquiry officer also, my lord. Why, how he has found, my lord, it is not mentioned, my lord. Basing on his inquiry report, my lord, it seems to be one-sided, my lord. My service was terminated by the impugn order, which I have annexed 121 page, my lord. Appellate also did not consider. Despite of my several grounds was there. There did not any whisper why my ground should not be taken into account. That is not there. They said, my lord, maybe after thought, my lord, not to be considered. Because they know very well. I have sent a legal notice. I have sent several documents. Only putting that, my lord, they said, my lord, I don't think there is a date also. When it was put up, my lord, no date. Or date is there, my lord. 25/8/21. They put a initial, my lord. So that's all, my lord. The impugn order has to go, my lord. If my learned singer replies anything, my lord, I may be given a chance to make a short reply.
Lord, first of all, the lordship will see whether, my lord, the allegation is that documents was not supplied. Now, your lordship kindly see the proceeding book, my lord. Lordship may skip first 2 pages, then the next page your lordship will find. My lord, your lordship may come in the middle. The inquiry officer asked, has your lordship got that?
Page,
Page, my lord, first 2 pages your lordship may.
proceedings of the departmental inquiry.
Right, my lord. Dated 18/3/2020. Then in the middle, your lordship kindly see the inquiry officer asked the defense side if they verified the documents as listed by the PO. The defense side replied that they verified the documents and submitted certificate to that effect. The defense side handed over the certificate to the EO and the inquiry officer marked it as defense exhibit 1. Now, the allegation that the documents are not supplied is a blatant lie. Because at first stage they have said, they're saying after the inquiry. Now here he has said, he has verified and then it was marked as DE1. Then, my lord, before going into merit, I will take your lordship to the inquiry proceeding. Your lordship may kindly come to page 2, my lord. Page 2, your lordship kindly see PO presiding officer, he has asked a question. Please go through the document so and so and tell the inquiry officer whether the photographs are fabricated or not. Now the answer is MW1, apparently it is seen that the background and sitting arrangement is same in all the photographs, but faces are different. In all apparently seem to be same photograph. Then, my lord, MW1, the signature is of the CSO, that is charge sheeted officer, as per signature done in ME4. Now the signature there is of the charge sheeted officer. Then down below, your lordship may come again. The inquiry officer asked the CSO if he would like to cross-examine MW1. The CSO said he would not cross-examine MW1.
Where is that? Where is that?
That down below, my lord, page 2, before last, from bottom 3 lines above, your lordship will find the inquiry officer asked the charge sheeted officer if he would like to cross-examine MW1. There is management witness 1. His reply, the CSO said he would not cross-examine MW1. Now, in every, my lord, in all the charges which were proved, he was asked whether he would like to cross-examine. He said emphatic no, I don't want to cross-examine. Then, my lord, I will take your lordships to page 4. Page 4, my lord, line about from top. 4. PO, please go through the document ME6G and ME6H and tell the inquiry officer whether there is any similarity of the group photographs. MW1, the same photographs is attached in both the loan documents. Then, my lord, your lordship, can in the middle part, the PO declared from there. The PO declared that his examination in chief of MW1 regarding MW so and so is over. The EO asked the CSO if he would like to cross-examine MW1. The CSO said he would not cross-examine MW1. Now you don't want to cross-examine. Then your lordship kindly come to page 7, my lord. It is regarding verifying of signature of officials. Your lordship may from the bottom, line about 6. Presiding officer, please go through the documents ME5G and check whether KYC documents of all group members are available with the documents. So these are charges, my lord, my lord, allegation against him, and whether the KYC documents were made by him. MW1, there are copies of PAN card of Josna Ara Begum and copies of voter ID of Josna Ara Begum and Runuma Begum available with the loan documents. Please go through the documents ME4 and check whether signature of the verifying officer of the KIC documents of ME5G matches with the signature of the CSO. MW1, yes, the signature of the verifying official of ME5G matches with the signature of CSO. Then your lordship may see at page 9. Line about from top line about 10, my lord, MW1. So before that, PO, please go through the document ME4 and check whether signature of the verifying officer of the KYC documents of ME6J matches with the signature of the CSO. MW1, no. There is no any authentication in the KYC documents. Now this is regarding KYC documents. And then my lord, page 10. In the middle, my lord, your lordship will find MW1. There are copies of PAN card of Manjila Begum and Shabiha Begum and copies of voter ID of Manjila Begum and Shabina Begum. Please go through the documents ME4 and check by the signature of the verifying officer of the PIC documents of ME5F matches with the signature of the CSO. Yes, the signature of verifying official matches with the CSO. Then at page 11, the inquiry officer asks the CSO whether he would like to cross-examine MW1, which your lordship will find from bottom line about 8, my lord. The PO declared that his examination in chief of MW1 regarding ME so and so, charge number 1 is over. The EO asked the CSO if he would like to cross-examine MW1. CSO said that he would not cross-examine MW1. Then page, the next page your lordship will find, my lord, DW, he himself said he will defend himself in the middle of the inquiry. The inquiry officer welcome all present for hearing, declared that he is going to start the third day of hearing. The inquiry officer asked the CSO whether he has appointed any defense representative at this stage to defend his case. The CSO replied that he has not appointed any defense representative. He will defend his case himself. Now, argument was made some point of time that, my lord, he was not allowed to defend his case. Or, my lord, he was not allowed to engage any defense representative. That position is not correct.
That I have not said.
No, earlier, no, not today. The earlier occasion that argument was advanced. Now, in the next page, your lordship kindly see. In the middle, deciding officer, please go through the document ME1 so and so so and so. MW1, yes. Dadul, son of Hassan Ali, is a member of Kushal. Now, there are, my lord, if I go through the charges, this thing will be clear to your lordship. My learned friend did not read the precise charges drawn against him. My lord, I would like to take your lordship to that. Then this thing will be clarified. Your lordship may come to page 52, my lord. This is the article of charges.
Yes.
In the middle part, article of charges, during the tenure of your service as branch manager of banks, Garuputi branch from 25/2016 to 7/5/2019, you have sanctioned and disbursed altogether 217 numbers of self-help group loans within a period of 16 months from so and so, altogether an amount of rupees 4,15,20,000. While sanctioning these loans, you had committed gross and serious irregularities, details of which are narrated below. In the following cases, group photographs attached with loan documents are found to be fabricated. That is, only the faces of the members were changed to defraud the bank. Detail of the SHG are as follows. Now, these are the group, my lord, the 1 to 7. Their faces are digitally altered. And that has been, my lord, proved in the inquiry. And the officer was asked whether he want to cross-examine. He said no. He did not cross-examine any of the issues. And further, my lord, there is no evidence on his part. He could have said, I denied all these things. This is not my signature. He did nothing. So therefore, on the face of all these things, these are all admitted. Now, the photographs were verified and authenticated by you. It clearly indicates that fictitious loans were created by you in connivance with outsider and the bank has been defrauded. Then B, in the following cases, same group photo was attached with loan documents, though name of the SSG, name of group members are different, which implied that fictitious loans were created. Then, my lord, next page, This is chart number 2. KYC documents of all members were not obtained. Those obtained for office bearers of the groups are found to be fake, tampered, which are also authenticated by you. Now, these are the charges, my lord. This has been emphatically proved. Then chart number 3, page 54. As per RBI guidelines on self-help group, a person cannot be a member of more than one SSG. But in many cases, a person has joined multiple SSGs as member and avail loan. Now, my lord, self-help group, one member will have to be in one group only. Now, your lordship will find one member happens to be the group member of another SSG, self-help group. Now, these are the violation. Now, the 4, my lord, your lordship may come down. Loans were sanctioned to cash credit for the purpose of interlending, that is onward lending among the group. You had disbursed the loans by transferring the same in installment to the SB account of respective SSD. Subsequently, self-drawn checks issued by the self-help groups were transferred to SB account of some other individuals. Now, this interlending system introduced by the bank, it should be, my lord, the loan will be given by the members, between the members only. Now, your lordship will find they have issued self-drawn check, say, I am having a personal account. From there, I am issuing a check to him. So this is, my lord, not for the enhancement to the business purpose, but for their self-interest. Now, these are the, my lord, huge sort of, my lord, allegation against the manager, and it was proved in the inquiry. And these gentlemen, when he was asked to cross-examine, he said, no, I don't want to cross-examine. Again, bank's withdrawal slip is meant for cash withdrawal only from saving bank account by an account holder. But in many cases, withdrawal slips were treated as transfer voucher, and a huge amount from different saving bank account of the self-help group were transferred to SB account of a few individuals. Now, in a bank, your lordships know that they give withdrawal slip. That is for, my lord, I have an account, I can get it from the bank withdrawal slip, and that will be for the purpose of from my account I withdraw. But here, in that case, what happened? This withdrawal slip was used as transfer voucher. So I want to transfer 5,000 in the name of Mr. Rahman. Now, by virtue of this transfer order, I mean, this cash voucher, I am transferring the amount, which is an illegality committed at the instance of this manager. Then, my lord, chart number 5, you had sanctioned loan of rupees 1,90,000 to Kushal Kanwar Atmashay Gut. This is one group, my lord. The loan was granted to this group, account number so-and-so, customer ID so-and-so, for the purpose of interlending. There was an existing saving bank account bearing number so-and-so, customer ID so-and-so in the name of Kushal Kanwar Atmashay Gut, as the self-help group, wherein members of the group were as shown in the level below, and column B, the loan was sanctioned in the name of Kushal Kanwar Gut, and the loan amount was created with same customer ID of the SHG, but documents were executed by the members appeared in the column C. Lordship kindly see. The amount was sanctioned, say, in the name of Mr. X, and the documents were created in the name of Mr. Y. And this gentleman, he happens to be a bank manager, and this sort of things he has done, and it is not denied, and no even cross-examination. And they want, my lord, this, they should be given all benefit, everything should be caused. Now, though the loan was sanctioned in the name of Kushal Kanwar Gut, members listed in column C had availed the loan, wherein the seal used is appeared as Kushal Kanwar Gut. The loan amounts were routed through SB account number so-and-so. Now, this SB account number is different account number. Now, the entire transaction was routed to this account. Now, the SB account number so and so was a dormant one. Your lordship kindly see is a dormant account since 24/3/2014. On 8/2/2017, the account was activated by you and Kalpana Devi. Neither request letter of the group is found, nor was KYC updated. It implies that you accommodated the dormant account for fraudulent transaction and misappropriation bank loan by you in connivance with outsiders. Now, my lord, if my account has become dormant, the natural thing is that I will have to file an application before the bank. Bank will scrutinize, they will give a form to fill up the KYC form. If it is completed and if it is, everything is valid, then my lord, the account will be activated. Here, my lord, there was no application for activation of the account because the manager, he himself activated on his own just for the purpose of this fraudulent purpose. These are the huge allegation against him. Then the resolution adopted with the group for availing loan was on 26/2021. Your lordship kindly see how fantastic. The resolution was on 26/2017. And the president secretary had applied for the loan before that. That is on 25/5/2017. Unless he has any personal interest, how he can do that? Then, my lord, I am skipping these two. Then similarly, loans were sanctioned and disbursed in the name of defunct SHG. Lordship kindly see a group, the self-help group, which is defunct. When a loan was granted, in fact, the loan were sanctioned and disbursed also, my lord, in the name of defunct SSD, and their SB accounts were used without the knowledge of group members. Group members are not knowing. It was activated. One example is Neha SSG. On 14/2/2017, an amount of rupees 1 lakh only was transferred from SB account so and so to Jaimati SSG to SB account number so and so of Javed Miadat. The transaction is found to be unauthorized, fraudulent in nature on the following grounds. Now, my lord, in every respect, your lordship will find these are all unauthorized. Then the next page 56. Chart 7. You had sanctioned the following loans with stipulation of collateral security in form of term deposit, but term deposit were created out of loan installment disbursed. Now, my lord, generally loan is granted on the condition that you will have to make a term deposit in the bank. Now, what he did here, my lord, loan was granted after getting the loan amount, term deposit was created from that loan amount. Now, how they can flourish in the business? Because the amount is taken from the bank for doing the business. Now, if you are half of the money you are investing in the term deposit from that, then it means you do not have money to invest in the term deposit to comply the terms and conditions. And after taking the loan, with the help of the manager only it can be done. Because first, in order to avail the loan, you'll have to create the term deposit. Now, there is no term deposit created. It was created after availing of the loan with the bank money. Then the charges are all like that. Now, my lord, I will take your lordships again to the inquiry report I took earlier. So now I'll take your lordships to that part of the departmental proceeding, my lord. Which we payment. Now I'll take your lordships to phase 2 of the departmental proceeding dated 13/5/2020. Thirteen 5/2020.
13/5.
2020. In the top, your lordship will find left hand side.
Your records.
My lord.
Cancel. 13.5.
Lord, can I assist your lordship? If I get.
Yes.
My lord, the next page, your lordship can see.
Page 2.
Page 2 in the middle. Presiding officer, please go through the documents, so and so, so and so. Is a member of both the SSD. Yes. Then PO, please go through the so and so of all the members. Yes, Ajijur Rahman, so and so, hearing number so and so, but he's not the member of Rupai SSG. Then PO, please go through the ME 6S, ME so and so, whether Farida Begum is a member of all the three SSG. Yes, Farida Begum is a member of all the, these I am showing. As a lordship has seen in the charges that the Reserve Bank of India guidelines is there. A member will have to be only one member of the one SSG. Now, they cannot be member of other group. Now here it has been proved Farida Begum is a member of all three self-help groups. Now how the manager can allow all these things? Then please go through the ME so and so. MW1, yes, Jarina Begum Jami is a member of 4 SSD. In order to show that, my lord, I have taken to your lordship. In page 3 also your lordship will find. These members happens to be members of 3 or 4 SSDs. And then the last part, your lordship, see, the inquiry officer asks the CSO if you would like to cross-examine MW1. The CSO said he would not cross-examine MW1. Then, my lord, then your lordship may skip to inquiry dated 22/5/2020. That is in regard to, my lord, amounts are being withdrawn by issuing self-drawn. Your lordship may skip. In there also the question was put whether they like to cross-examine. He said that I don't like to cross-examine.
Before that, my lord, lordship will see, but the charge officer's signature is there or not.
Yeah.
If it is not there, it cannot be. That your lordship will examine.
That is
Apart
there.
from this, my lord,
My lord, it's an inquiry proceeding. Without seeing that, I will not place to your lordship. That signature of CSO is there.
apart from that, my lord, there is no affair till date. No affair. If
Let
it
me, my
is
lord,
written in-
I think he should not interfere.
Why
He
not?
should not disturb because my flow will be disturbed now. And my lord, I am a responsible officer of the bank, my lord, spokesperson of the bank. Had there been no signature of the CSO, I will never place it before your lordship. Because if his signature is not there, it is not authenticated document. I have seen it, the mark, his signature is there in every pages. Now, this also in regard to self-drawn check. Now, there also he was asked whether he would like to cross-examine, he said no. So this is for that purpose. Then the next, my lord, your lordship may come down after skipping these 2 pages. Inquiry dated 26/5/2020. That charge was in regard to,
1 minute.
well,
This page 1 of inquiry dated 22/5/2020.
my lord,
You can just read out that somewhere in the middle, the CSO replied.
my lord, your lordship is in 22/5/2020,
No, page 1.
page 1. The CSO replied that he has already verified all the documents to his satisfaction and want to withdraw his appeal to hand over him to photocopies of all documents related to his charge sheet number so and so, so and so. He submitted a letter withdrawing his earlier prayer requesting to deliver him the photocopies of all documents. The inquiry officer asked the CSO whether he has verified all the documents to his satisfaction. The CSO replied that he has verified all the documents to his satisfaction and he will not ask for any photocopy of documents in future. So these things are very clear. He is not denying because at the very outset he has said, I have verified, I have taken all the documents, and that is marked as DE1. So therefore saying that he did not get, and when he is saying after the inquiry, he is saying all that. He was given all the scope, whether you want to cross-examine, he said no. Then my lord, inquiry dated 26/5/2020. This is, my lord, in short, in regard to dormant inoperative account was activated on 8/2/2012. Now, your lordship may see it, examination and chief of MW1. Please go through ME so-and-so whether the customer ID of both the account is same or not. Whether the same customer ID was used to open both the accounts. MW1, the customer ID of both the accounts is same and the same ID was used to open both the accounts. Please go through ME so-and-so whether the same name of customers being member of Kushal Kanwar SSG, both the accounts are same. MW1, no. There are 10 members in the Kushal Kanwar SSG, but all members found to be different in both the accounts. PO, please go through ME1 and ME13 and tell inquiry officer whether the dormant inoperative SBI account number so-and-so, that is, my lord, the Kushal Kanwar, that one, of Kushal Kanwar SSG was activated on 8/2/2017. MW1, yes. Please go through ME13 and tell EO who have activated the account. The account was activated by Kalpana Devi and authorized by the CSO. Please go through the so-and-so whether loan application was submitted by the SSG prior to resolution passed in the group meeting. Yes. The application for loan was submitted on 25/5/2017, but the resolution was adopted on 26/2017. Now, these are the things as I have shown from the chart sheet that they have, in every respect, my lord, they have defined. This person has no respect for the bank. My lord, 18 and 20, my learned friend argued that this is something, and the my lord, charge was given in some other. 18 and 20 has a meaning. I'll take your lordship at last mail. Now, my lord, in the next page, if your lordship look at, the inquiry officer asked the CSO if he would like to cross-examine MW1. The CSO said he would not cross-examine MW1. So in all the charges, my lord, he has said he do not like to cross-examine. Then, my lord, I will take your lordship to the last page, that is page 6.
Last page.
Last means last of these inquiry dated 26.
Yes.
My lord, your lordship, the PO declared in the middle portion, your lordship will find. The PO declared that his examination and the chief of MW1 regarding ME so-and-so against charge number 8 is over. The EO asked the CSO if he would like to cross-examine MW1. The CSO said he would not cross-examine MW1. EO asked the PO to produce his witness, if any. PO replied that he has no other witness. Then inquiry officer informed both the sides that if they have nothing more to examine or re-examine, he will come to the conclusion. Both sides declared that they have no more to go ahead. Now, your lordship, kindly see. This CSO could have said that I want to adduce evidence. He did not. He could have said, I did not do all that. Now they are filing an application. They are saying before the general manager, I asked for document. They did not give document. I am not the proper person. The other scrutinized person is somebody, some other officer. Now they could have said at that time. He could have given the evidence. He did not deny anything. Now the entirety of the thing, my lord, it's amply clarifies that he is the person, he is the guilty in all these things. On the face of his, there is no evidence being adduced by him. Then the inquiry report, your lordship has seen on the basis of this. The inquiry, all the charges have been proved, they have clarified why it is. Now I'll take your lordships to the regulation, why you have said the regulation 18 and 20. The lordship will find that the regulation 18 and 20 comes under the chapter 4, conduct and discipline. My lord, in banking organization, my lord, those in position of authority, my lord, should avoid even the implication of impropriety. Now, your lordship knows that my lord, Julius Caesar, he was a Roman ruler. My lord, what happened? My lord, there was a party had thrown by his possibly third wife. Now, a person named, I forgot his name, sneaked into the party. And the Julius Caesar, he thought this person is unauthorized. Why he will come a party thrown by his missus? Then he was caught. He was given to the police. There was a trial. After the trial is over, he has divorced his wife, saying that I have a doubt about her propriety. So that is the position in regard to the officer in banking. My lord, they are dealing with the public money. My lord, the inbuilt quality of trust and all these things are there. And if you do all these things, the public money, and you are doing at your whims all these things, and you say that the penalty of dismissal is huge, and dismissal is the bank is also not aware of what punishment they are imposing. Your lordship will find that this penalty of dismissal is discernible from the facts and circumstances of the case. And my lord, the Supreme Court has time and again has said, my lord, if there is no precise provision quoted, here provision is quoted, but I am saying, I am using the word precise provision. That means, my lord, I will take your lordships to 39. 39 says, my lord, is a compartmentalized minor penalties, major penalties. 39(1)(a), 39(1)(b). Now, my learned friend argument is this: he is not aware of under which of the part he has been given punishment. Punishment is given, the word dismissal is used, it is under 5, and it is discernible under the facts and circumstances whether he should be given lighter punishment or heavier punishment. So obviously, from the facts and circumstances, and I can, my lord, I'll produce some of the decision of the appeals court saying that, my lord, non-mentioning of a provision in the, my lord, particular area, my lord, it will not vitiate the proceeding at all. Even there is no provision quoted and the punishment is also given, it will not vitiate the proceeding. Here provision is quoted, but precise provision is not there. My lord, that will not vitiate the proceeding, so long the authority has the jurisdiction. Now, here the authority has the jurisdiction, and the from facts of circumstances is discernible that only punishment is existing. And your lordship kindly say 14 and 18 and 20. 18 is liability to abide by the regulations and audits. Every officer or employee shall conform to and abide by these regulations and shall also observe, comply with, and obey all orders and directions which may from time to time be given to him by any person or persons under whose jurisdiction, superintendence or control he may for the time being be posted. That means he will have to conform to the, my lord, guidelines and all the periphery of regulations that he will have to comply. Then 20, obligation to promote the bank's interest. Every officer or employee shall serve the bank honestly and faithfully and shall use his utmost endeavor to promote the interest of the bank and shall show courtesy and attention in all transactions and dealings with officers of the government, the bank's constituents and customers. So these are the things must be inbuilt with the officer of the bank. Now, therefore, this is violation of regulation 18 and 20. Because a bank officer, you will have to maintain all integrity. My lord, in a case, my lord, a state bank officer is the manager of the state bank in possibly Hyderabad. My lord, what happened? He sanctioned a loan in the name of his wife. Then ultimately, my lord, he thought that I am doing some illegality. He stopped that sanction. And but then the management said that there is in the regulation, there are some restrictions. And why did you sanction? And ultimately, my lord, he was removed from the service. He went to High Court. High Court has also dismissed. Went to Supreme Court. Supreme Court also dismissed it because the integrity is in question. Because these sort of people cannot be relied. When the confidence is shattered in the bank, that is end of the matter. My lord, the bank may not incur any loss. Even then, when you are not a reliable person, as I have said that like Julius Caesar, when he found that his wife cannot be relied, now he has divorced. Now, that sort of integrity one must, my lord, possess in the bank. Now, my lord, I will take your lordship certain time is there, possibly I can take another 15 minutes. Now, my lord, in regard to another, my lord, my learned friend argue that the appeal was not disposed of by giving reasons. Now, my lord, he has in his affidavit, where is that? He has annexed that, my lord, your lordship may see. In page 143. Page 143.
Yes.
Charge sheet by letter number so and so was issued to Sri Mukul Chandra Sharma as per CBO's advice under major penalty for committing irregular sanction and disbursement of loans and advances during his tenure of service as branch manager. The charges in brief are during the tenure of his service at so and so, Mr. Sharma had recklessly exercised his DP in sanctioning and disbursement of 217 numbers of SSD loans involving total amount of rupees so and so, with gross and serious irregularities as under. Among the all borrowed self-help groups, in many cases, numbers of persons are members of multiple self-help groups. Same group photographs is used in 5 numbers of self-help group loans sanctioned. In 7 numbers of SSG loan groups, photographs attached with loan documents are found as fabricated. KYC documents of the president secretary obtained in 11 numbers of self-help groups are found fake, tampered. Loans were sanctioned to self-help group as CC for internal lending, but disbursement made in pages STL mode. Disbursed amount were credited to SB account of borrower SSD and thereafter transferred the amount to SB account of some individuals using self-loan withdrawal forms of checks without valid consideration. A loan amount of rupees 1.990 lakh was sanctioned to Kushal Kumar Good, but disbursement made through SB account of another SAG, Kushal Kumar Atma Shenna Good. An amount of rupees 1 lakh was fraudulently transferred from SB account of Jayamati SSG to SB account Javed Miadat. The transaction was occurred through a self-loan check where the president secretary of Mijuli SSG signed as drawer instead of Jayamati. Most of the SSG loans are turned into NPA, quick and early mortality effect category. Further, the Vigilance Committee had head office in its meeting held on so and so and directed to 57 lakhs 8,000 and odd as fraud occurred at Garukuti branch in the loan sanction and disbursed of different SSDs. After completion of the department inquiry, all the charges level against the Sharma had been proved beyond doubt and accordingly punishment. Now, these are the reasons, my lord, given why his appeal could not be considered. And it was approved by the chairman himself. So therefore, it is not that appeal was not considered by giving reasons. The reasons are these, and in terms of that reason, chairman has approved this. Now, my lord, I will take your lordship to certain decision of the apex court. My lord, first decision is 2023 SCC 423.
2000?
2020 volume 3 SCC, page 423. My lord, I'll read paragraph, a small paragraph, paragraph 8 to 15. My lord.
8 to?
8 to 15. 1-5. We find that, para 8, my lord, we find that the interference in the order of punishment by the tribunal as affirmed by the High Court suffers from patent error. The power of judicial review is confined to the decision-making process. The power of judicial review conferred on the Constitutional Court or on the tribunal is not that of an appellate authority. In State of AP versus Sriram Rao, a 3-judge bench of this court has held that the High Court is not a court of appeal over the decision of the authority holding a departmental inquiry against a public servant. It is concerned to determine whether the inquiry is held by the authority competent in that behalf and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. The court held as under. The High Court is not constituted in a proceeding under Article 226 of the Constitution of a court of appeal over the decision of the authorities holding a departmental inquiry against a public servant. It is concerned to determine whether the inquiry is held by an authority competent in that behalf and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. Whether there is some evidence, your lordship can see this language, whether there is some evidence with the authority entrusted with the duty to hold the inquiry is accepted, and which evidence may reasonably support the conclusion that the delinquent officer is guilty of the charge. It is not the function of the High Court in a petition for a writ under Article 226 to review the evidence and to arrive at an independent finding on the evidence. In BC Chaturvedi's case, again in 3-judge bench of this court has held that power of judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receive fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eyes of the court. The court tribunal in its power of judicial review does not act as an appellate authority to reappreciate the evidence and to arrive at its own independent findings on the evidence. The other part, your lordship may skip me. Then para 11. In High Court of Bombay versus so and so, this court held that interference with the decision of departmental authorities is permitted if such authority had held proceedings in violation of the principle of natural justice or in violation of statutory regulations prescribing the mode of such inquiry while exercising jurisdiction under Article 226. Then paragraph 12. The State Bank of Bikaner versus so and so, this court held that the courts will not act as an appellate court and reassess the evidence led in the domestic inquiry or interfere on the ground that another view is possible on the material on record. If the inquiry has been fairly and properly held, and the findings are based on evidence, the question of adequacy of the evidence or the reliable nature of evidence will not be ground for interfering with the findings in a departmental proceeding. It is well settled that the courts will not act as an appellate court, and your lordship has seen that. Then your lordship may see paragraph 13. In another judgment reported in Union of India versus so and so, this court held that while reappreciating evidence, the High Court cannot act as an appellate authority. These are in the same line, my lord. Then paragraph 15. The disciplinary authority agreed with the findings of the inquiry officer and had passed an order of punishment. An appeal before the state government was also dismissed once the evidence has been accepted by the departmental authority in exercise of power of judicial review. The tribunal or the High Court could not interfere with the findings of fact recorded by reappreciating evidence as if the courts are the appellate authority. We may notice that the judgment is notice, notice the larger bench judgment in Sri Rama Rao and B.C. Chaturvedi and mentioned above. Therefore, the order passed by the tribunal and the High Court suffered from patent illegality and thus cannot be sustained in court. Next. The next decision was 2012-13 SCC, page 142. My lord, para 56, my lord, this I am referring because I have given an example of Caesar's wife. My lord, the lordship has, my lord, mentioned about that here. At paragraph 56.
Yes.
It must be emphasized that bank officials act as trustees of funds deposited by the public with the bank. They have an obligation to earn the trust and confidence of not only the account holders, but also the general public. The standard of integrity here, madam. The standard of integrity required of the bank officials, particularly the cashiers, accountants, auditors, and the management. Management means he is a manager here. At all levels is like the Caesar's wife. They must be above suspicion. Mr. Bhosle failed to maintain such high standards of integrity. He therefore acted in violation of Rule so and so. We therefore do not find any merit in the approach's submission. Now, for the purpose of that only, I have shown to your lordship. Now, this 2007-15 SCC, this decision, my lord, I am referring, your lordship will find my lord, in a banking institution, if a officer, my lord, if they say that there is, if because of my misconduct, bank has incurred loss, and I am reimbursing that along with the interest. Even in that circumstances, my lord, misconduct, you may give money back, but misconduct cannot be obliterated. In that sense, my lord, in paragraph 6, 2007-15 SCC, page 775, paragraph 6. Lord, paragraph 6, learned counsel for the appellant also submitted that the appellant has already paid back the money which was held proved against him that he had misappropriated. Mere payment of money does not absolve him of serious charge of misappropriation. The last submission that the punishment imposed on the appellant is too hard also does not appeal to us. Having regard to the serious nature of charges, including the misappropriation of money, and issuing a receipt on plain paper and reflecting it in the official record as something else. The decision of so and so relied on by the learned counsel for the appellant does not help him, as that is a case which governs the fact of that case. The other decision relied on the purpose of so and so. Even this decision does not help the appellant in any way, as can be seen from the very facts and the opinion expressed therein that the order of dismissal having regard to the serious nature of the charge of misappropriation was felt appropriate. However, the penalty was modified on the peculiar facts of that case. Under these circumstances, we find no merit in the appeal, consequently, it stand dismissed. Now, regarding, my lord, the next case, 2006-7 SCC, page 212. There is a case of loss of confidence. Your lordship will find in paragraph 21 and 22. I'll read paragraph 21. Paragraph 21, my lord, confronted with the facts and the position of law, learned counsel for the respondent submitted that leniency may be shown to the respondent having regard to long years of service rendered by the respondent to the bank. We are unable to countenance such submission as already said. The respondent being a bank officer holds a position of trust where honesty and integrity are inbuilt requirements of functioning, and it would not be proper to deal with the matter lenient. The respondent was a manager of the bank and needs to be emphasized that the banking business absolute devotion, diligence, integrity, and honesty needs to be preserved by every bank employee, and in particular the bank officer, so that the confidence of the public depositors is not impaired. It is for this reason that when a bank officer commits misconduct, as in the present case, for his personal ends and against the interest of the bank and the depositors, he must be dealt with iron hand, and he does not deserve to be dealt with lenient. Paragraph 22. In this case, Mr. Francis also submitted that a sum of rupees 34,000 and odd, being 5% of the total loss of 6,88,000 something, is sought to be recovered from the respondent, and that the present departmental proceeding is the only known allegation against the respondent, and there was no such allegation earlier, and therefore a lenient view should be taken by this court, and relief rate for both the parties can be suitably molded by this court. We are unable to agree with the above submission, which in our opinion has no fruit. The scope of judicial review is very limited. Sympathy or generosity as a factor is impermissible. In our view, loss of confidence is the primary factor, and not the amount of money misappropriated. In the instant case, the respondent employee is found guilty of misappropriation of the corporation funds. There is nothing wrong in the corporation losing confidence and faith in such an employee and awarding punishment of dismissal. In such cases, there is no place for generosity or misplaced sympathy on the part of the judicial forum, and interfering therefore with quantum of punishment awarded by the disciplinary and appellate authority. Now, next is 1996 3 SCC 750. In that case, my lord, the apex court has held out of the several charges, even one charge is proved that is sufficient. The lordship will find that at paragraph 7. In paragraph 7, it is settled law that the court is not a court of appeal to go into the question of imposition of the punishment. It is for the disciplinary authority to consider what would be the nature of the punishment to be imposed on a government servant based upon the proved misconduct against the government servant. Its proportionality also cannot be gone into by the court. The only question is whether the disciplinary authority would have passed such an order. It is settled law that even one of the charges, if held proved and sufficient for imposition of penalty by the disciplinary authority or by the appellate authority, the court would be loath to interfere with that part of the order. The order of removal does not cast stigma on the respondent to disable him from seeking any appointment elsewhere. Under these circumstances, we think that the High Court was wholly wrong in setting aside the order. Now, my lord, these are all, my lord, your lordship has seen the factual background of the case, the charges, what sort of charges and how he has replied. He even did not bother to cross-examine that part of the witnesses so far MW1 is concerned. Further, he was asked whether he want to adduce any evidence. He did not adduce any evidence, saying that I did not do anything of that sort. It's not my signature. It's not my duty imposed on some other person. On the face of all these things, my lord, understands that the punishment given, it is quite appropriate punishment and it doesn't call for any interference.
Actually, what was the punishment imposed?
Punishment is dismissal. As I have said, my lord, appropriate, my lord, provision may not have been quoted here. So lordship may see 39. 39, there are, it is divided in compartmentalized 1A, 1B. 39 possibly. 39, your lordship, penalty defined. One is minor penalty, one is major penalties. Now, this comes under 39B. Now, the facts and circumstances is discernible, my lord, what sort of punishment it is. Now, my lord, the appeals court has time and again has said, if no provision is quoted or wrong provision is quoted or no provision is quoted, but then punishment can be imposed and the authority has the jurisdiction to do that. My lord, merely there is wrong provision quoted or provision is quoted, not precise provision is quoted, that doesn't mean it will affect the punishment given. The proceeding or the inquiry will not be vitiated at all. So these are all technical in nature because they have said 39B. B comes the major penalty. Now the facts enumerated, which has been established, which has not been denied, is not rebutted by the other side by any means. So therefore, merely because they did not spell out that it comes under 5, that will not vitiate. I can, my lord, I am not ready with that decision today. I'll give it to your lordship tomorrow, that decision. So it will not, non-quoting of the provision will not vitiate. The lordship has gone into many of the decisions that we, but today I am not ready. The recent decision is also there. I tried to locate, my lord, one new decision has come in live law, but I could not get the print of. I'll give it to your lordship tomorrow. I'll send a copy to my learned.
My lord, briefly, I'll reply to my
No,
what learned.
see, one thing is there, this one issue here, the other side is saying that it is not specifically required to show what order, what punishment was imposed. Maybe
My lord,
there's a.
yes,
there's
that
a-
my lord will be clear from the 39B itself, my lord. Reduction of lower rank. Why not this one?
No, that is why.
Let
So
1
in-
minute, my
in
lord.
Such a
Why not
situation-
compulsory? Yes, I'll give the judgment. I'll give the judgment, my lord. And apart from this, I did not know that my learned friend will bring CBL judgment. I'll give the judgment tomorrow itself in the court master. That point I'll clarify, my lord. They need to have mentioned. I'll rely upon the apex court judgment, my lord. It has been
No,
decided.
you, both of you bring your judgments, we'll take it up again, arguments are over. You have to reply only.
My lord, 1 second, my lord.
I'll give you a date.
Lordship, give the date, no matter, my lord. Only last, because we may forget, my lord. What I'll want to reply, very 5 minutes I'll take, my lord. Firstly, my lord, there is no misappropriation by me. Allegation never says. Whatever judgment my learned friend has relied upon, it seems, my lord, misappropriation was done. Number 2, no affair was lost against me, my lord, causing any loss to the bank. It is the obligation of the bank, my lord. If I cause any loss, they have to need to have file FIR. Secondly, my lord, the official record shows, my lord, 2012. I was not there 2012. Because I have not come across, my lord, whatever I learned from him, my lord. And so far document is concerned, my lord, page 119, 108, 110, my lord, 199 and 100, my lord. With the official signature, I asked the document you give me. Because I have seen he's doing bias. Lordship, for a moment, Lordship, can you see?
But records fix different.
My lord, if it is so, my lord, why they will put signature? What is the order passed on me that you have taken? You said this thing. They need to have decide on this. Because it's the official capacity I have given.
No. Issues, you've met your application, so they've received your application.
They receive, they need to say something, my lord. That you have already said this thing or that thing. Lordship, I have given, my lord, 3-5. And this office notice, Lordship has to see the date. Prior to the submission of the inquiry, I have given. Because in what happens in the inquiry, my lord, my practical experience is that matter. When high officer is there, you sit down, we'll see it. You sit down, we'll see it. These things are going. Anyway, my lord, and there is no inquiry report about, my lord, the credit officer. His duty is to examine and verify. I'll bring a judgment from the apex court, my lord. If I open an account, it does not falls any liability on me. That judgment also I'll bring. Lordship, fix the matter some other day, my lord, after tomorrow or.
Heard Mr. J. Bharwaya, Leonard counsel for the petitioner, also heard Mr. S. Datta, Leonard senior counsel appearing for the assessor by Mr. S. Datta, Leonard counsel for the respondent bank. 13 part, list for Friday hearing. We'll-
Only for the judgment, my
Yeah,
lord,
we'll
lordship.
give a short date. Tomorrow is what, Friday?
Friday, my lord. From 10 to 13, I'll be out of station, my lord. 7 is a holiday, 8 is a Wednesday. 9 or 16.
9th.
My lord,
Only for the
can it
judgment
be any
purpose, my
other
lord.
date? Not 9, my lord, some other date.
16.
Necessarily not on a hearing day also, we can just finish it off.
Only
Just
we
for
need this.
clarification. Yes, yes. Hearing is over, I think.
Hearing is-
Can we have it on Monday, 6th?
6th, my lord, I'll be out of state.
Okay, oh, give a convenient date.
16.
16, no problem.
16 will do,
Earlier
my
is better, my lord. Earlier is better. so
Earlier
that
is better
we don't
before.
So
forget.
lordship fix the matter on 9, my lord.
9.
No, no, just to need to give judge copies of the judgment, my lord, nothing else.
All right, in that case, okay.
You can retain this back. You can
Yes,
give me on the next.
9, my lord, only for submission of my lord judgment. By
Sometimes
both
it's used to get
Right,
used
right.
to this.
Only for judgment. No argument. Argument, lordship, maybe
21,
on 9.
9 is, okay, 9.
Oh, bless.
Lordship has kept as a part of.
Four,
Lordship, this is the matter pertaining to lordship selection and appointment to the post of.
Some other day.
Oh.
Today there's no time.
And lordship, in fact, lordship, there was 2 order passed by the honorable court on lordship, on 12/12/2022, there was an order passed by the honorable court. Why appropriate order should not be passed for interfering with the selection illegally made by the selection committee, which had resulted in charge sheet being filed against the committee members. Thereafter, lordship, there was another order on 19/12/2022. Commissioner Lower Assam Division took show cause as to why appropriate order should not be passed for interfering with the selection. Thereafter, lordship, they filed an affidavit. Commissioner Lower Assam saying that he is not liable. It is the revenue department who should show cause. That affidavit has not come till yet from the revenue department.
Now,
Wait,
Lordship,
please.
it is item number 4, Lordship. We are concerned with item number 4. Item number 4.
আমার কাছে
Item
9/12/2020 12/12/2022 and 9/12/2022. There are 2
1
orders.
minute. 9/12,
9/12/2022. Sorry, Lordship, 12/12/2022.
12/12,
12/2022 by Honorable Justice M. Buzar Borua.
1 minute.
Right.
12/12/2022. Yes,
Lordship, I have just quoted.
My lord, your lordship kindly see the last order. So that the order was already there. Thereafter, I filed application for vacating stay. In that vacating stay, my lord, court says that, my lord, actually, my lord, main case is that, my lord, there is a difference of name, my lord.
No.
My lord, that is the complete, then I will argue. Okay, you complete.
I am arguing.
Yes, you complete it.
Lordship, I am just, since there is no time, I am just showing that the order to pass orders
That
passed
order
by
is
the
already
Honorable
there. After
Court
my last order, your
on
lordship kindly see.
12/12 and 19/12. Thereafter, they have filed an affidavit, the Lower Assam Commissioner, saying that he is not liable. Now it is the Revenue Department who is the appeal authority. They should file an affidavit.
My lord, again, my lord.
Only to that extent, Lordship, I have just made my submission.
okay. Yes, Amanda.
My lord, here in this case, what happened, my lord, there is a difference of name only. My lord, page 47 and post 53. My lord, initially, my lord, result was published. That was, my lord, Nurul Islam Ahmed. One Nurul Islam Ahmed was selected. Then my lord, immediately Corrigan number understood it should be not Nurul Islam Ahmed, it should be my lord Nurul Islam Sheikh. So only difference Nurul Islam Ahmed and Nurul Islam Sheikh. Then my lord, there was expert stay order was granted, my lord. Then I filed application for vacating stay. Then this honorable court says who is getting highest mark who came to this order, let him produce before his court and a matter will be finished. That's why my lord, I am not proceed with the stay vacation petition. Now, my lord, your lordship kindly see that marks were produced before this honorable court that I am getting highest more mark than him. So rightly Corrigan number was issued. It was not he who was selected, it was I who was selected. So on that stage, my lord, last occasion, now he says that there is a criminal case pending. Well, all that in the district, everything is been, my lord, all other candidates were appointed. Now, my lord, your lordship kindly see the last order, what they said, my lord. So he is applying to an order he was passed initially ex parte, my lord. So now, my lord, your lordship kindly, if your lordship, my lord, not here
Now,
today,
also,
then,
if your lordship is taking up this matter for final disposal, lordship, then let me start.
No, we can't.
so you're like, your lordship kindly fix a date, my lord. And now, my lord, he cannot even challenge the select list because, my lord, he is not in their pair, my lord. He just says that, my lord, who is getting highest mark, he will be appointed.
Revenue, are you filing your affidavit? Anybody agreeing? Yeah, handy.
Revenue file will take it. No, no, no. In fact, my lord,
Lordship, Deputy Commissioner, that's appointing authority, Lordship, filed the affidavit.
Okay, but Mr. SK does.
A record is here, Lordship.
No. Okay, then say like this on request made by the parties. When do you want? The matter after? 1 week?
Not.
Okay, after 1 week.
your lordship kindly fix it that if I am appointed, my lord, I will be going to retire after 1 year.
It's the matter on. It is what first. Second. It has to be on a hearing day or any day?
Any day.
14, my lord.
14.
14, lordship, let it be on 15, lordship, or
15.
15.
lordship, there's an interim order according, lordship, that may be kindly get.
Interim order passed.
5 and 6.
Lordship, in this matter, Lordship, it will take some time for arguments, Lordship. I'm praying for the date, your Lord.
Our
Accommodation for today. Readings are completed.
I will take time, my lord.
Let it be in the admission column only.
Okay. When do you want?
9th, we have some urgency, your lordship. The issue is like this. They're enjoying the interim orders.
That's true.
Now, the posters ought to be advertised again, your lordship.
Okay, on request made by the parties, list on 9th.
Lordship, if it is 10th,
No, 9th.
hearing day lage. Lordship in 14th or 16th, any date or not, subject to convenience of lordships and my senior counsel.
I'm always around, it's your convenience.
Okay. 14th or 16th, what are hearing date?
23rd.
23rd is a restricted holiday. Also 23rd, Lordship, I have no problem.
23rd is a holiday.
Holiday. Holiday. 21st to the Tana Satara.
28?
I'm fine for 28, otherwise, subject to convenience of my.
Yes, your lordship.
2 weeks, Lordship.
List the matter on 28.
Your lordship, it may be recorded. They have paid for time today, your lord.
Lordship.
Okay, on request made by Mr.
DJ Das on behalf of the
DJ
petitioners.
DJ Das, Leonard Counsel for the petitioners. List
Both the
the matter on 28. Any interim is there?
Lordship, there is an interview.
It needs to be extended or is it absolute?
No, Lordship, not to be extended. Not to be extended, Lordship. It's already until further orders. Lordship, actually, there is an interim order by the by the division bench only.
Okay, your lordship, one record may be, a instruction may be directed to be produced by the APSC that these candidates are exempted candidates.
there are 8 papers. They failed in many papers. They got exemption in 1 or 2 papers. So if they pass in the subsequent examinations, the exempted candidates, even if they pass in the subsequent examinations, whether their names will be reflected in the down below the merit list.
That we'll see when we take up the hearing.
That
We
instruction.
have filed affidavit,
That instruction is not there. So what, as per my instruction, suppose even if they pass the examinations next time, their name will be at the bottom of the merit list of all those candidates who had passed at one go.
We'll see. Yes, next.
7,
Deeply obliged, Your Lordship.
Lordship, here in this case, except respondent number 4, all the appearing respondents have filed the affidavits. Lordship, yesterday, if, 2 affidavits has been filed, today 2 affidavits has been filed.
Who is respondent for?
Record maybe call for whatever documents we have filed, my lord.
Have you filed your
I am,
affidavit?
my lord, APS already filed.
Taking the extent of FPSC, my lord.
Then I'll record that you are not filing a.
Yes, madam. Record maybe call for, my lord.
Okay, heard, Mr.
D does.
D Das, then the counsel for the petitioner. Stop, Mr.
Yes, board, my lord.
S. Botago, and the counsel appearing for respondent number 4 submits that he will not be filing a counter affidavit. Stop. Accordingly, list the matter. When do you want?
Lordship, I will require 2 weeks time to file the rejoinder.
List the matter after 2 weeks.
By fixing a date, Lordship.
No,
Lordship, kindly fix a date,
list the
Lordship.
matter after 2 weeks. In the meantime, the APSC.
We have already filed affidavit. As number 2 and 3 already filed.
You produce the records.
My lord, I mean, details affidavit, they have filed, my lord.
Okay.
And affidavit will do.
I am taking the extent of FPSC, my lord.
Lordship, can it be on 20 or 21st, Lordship? And to fix that, Lordship, I humbly request.
27th.
Lordship.
8,
May I please, Lord? In this case, I am carrying for respondent 8, my lord. I mean, not so late the matter be come after 3 weeks, my lord.
You have for respondent
8.
on request made by Mr.
B. Rahman.
B. Raman.
Yes, my lord.
Counsel for the response number 8.
8.
List the matter when.
My lord, both parties are also here. See, he's for petitioner, my lord. After 3 weeks, my lord. Then date, then my lord 30. 30.
30.
Hello.
9,
Lordship, this matter is about removal from service and here the answering respondent is the Assam Agricultural University. They are supposed to file affidavit as they have been instruction and last occasion they have stated. But they are absent.
But Mr. Abdul Magundal and the counsel for the petitioner. None appears for the Assam Agricultural University. List the matter again after 1 week, 2 weeks.
Lordship, this petitioner is bedridden and he is eagerly waiting to see the outcome of the petition. The date may be fixed, Lordship.
Yes. 21 after 1 week, 2 weeks.
Yes, 1 week.
13th.
Obliged.
10,
The matter may be taken up on 38th of May.
38th.
My lord, they have filed an reply to the rejoinder, my lord, but without taking off the leave of this honorable court. On the earlier, as per the earlier order, my lord, the pleadings are already completed, my lord.
Okay.
My objection may be recorded, my lord.
And copy, you may take the copy
My
also.
lord, we have not received the copy also, my lord.
Because you have refused to take the copy.
My lord, because since the pleadings are complete, my lord, without taking leave of this
There is
honorable
no bar
court,
in
how can they file
clarifying
an
certain facts.
What have you filed?
Because they have filed a rejoinder, my lord, on certain new facts has been brought. So we have clarified that new.
How can you keep on going like that?
Now only this one because they have brought in new facts, my lord.
my lord, they ought to have take permission before of this honorable court before
At least
filing.
some
To expedite the matter, my lord, so that we have filed day of.
How can you expedite the matter with the court? At least some permission.
I
should
will,
have
I will
been taken.
file a IA, my lord, to take leave from this honorable court.
Okay.
My lord.
Mr.
Vidas, my lord.
BK Singh, my,
BK Singh Leonard, Standing Counsel,
my lord.
FCI. Press for filing an appropriate application for filing an additional affidavit, correct?
Reply to the rejoinder filed
For
by the
filing
petition.
reply to the rejoinder filed by the petition. Stop. Press allowed, list out
30, 35.
30,
30 minutes.
30.
Eleven.
Wait, please, your lordship. Your lordship will not have last order, lordship. The government advocates were supposed to instruction, lordship, whether the suspension of the petition was reviewed by the authorities or not, lordship.
Where's the status of the departmental proceeding, lordship? Yet to receive, lordship. Instruction yet to be received, lordship. Just say.
What's taking you so long?
It's the order of 9/4, your lordship, almost a month,
Yes.
almost a month.
On that day, lordship, we sent a letter, lordship, due to election, lordship. I think, lordship, after 7 any date, lordship.
Okay, heard, Mr.
And got to my lordship.
N. Gaudam, Learned Counsel for the petition. Mr. J.K. Goswami, Learned Additional Senior Government Advocate, submits that he has not received instructions and prays for some more time. Stop. Please, praise the Lord, please the matter on 70th election, isn't it?
7 days election, your lordship.
We'll have it on 13th.
Lordship, actually, for item number 8, Lordship, it has been fixed on, I think 30th of May, maybe. Lordship, on that date, my senior will not be available here. So can it be on 22 or 23rd? Lordship, other side is here. I have informed the other side.
Item 8, what order was?
Item 8.
Why do you come in the middle, you proceed, wait for some time? Orders have already been passed, you come the next day when it is fixed.
Well, hearing.
That is your lordship.
Yes.
Your lordship, finally the matter may be passed over for the day as my senior is on leg at court number 17.
Your seniors, MS R. Chowdhury.
Yes, lordship.
On request made on behalf of MS R. Chowdhury, Learned Counsel for the petition. When do you want?
On 9th, lordship. Can it be fixed at 2, lordship?
Use the matter on 9th.
At 2 p.m., lordship.
We'll see.
Yes.
15.
Wait, please, your lord.
This is against dismissal from service, Lordship.
Okay. Who's on the other side?
Lordship, can you fix another date, lordship, for hearing, lordship? We will proceed. Here, some peculiar circumstances is there, lordship. The original record was missing, lordship, and we had submitted our affidavit, lordship. Although, lordship, your lordship direct asked that to produce some documents, lordship, that is yet to be received from the department, lordship. Kindly fix the matter after 2 weeks, lordship.
Okay, heard, Mr.
R. Fukan.
R. Fukan, Learned Counsel for petition. On request made by Mr.
J.K. Goswami.
J.K. Goswami, Learned
Additional.
Senior Government. List the matter after 2 weeks. Enable him to produce a
I'm
report.
praying for a date, Lordship, 2017 meter in the second week of May, Lordship.
16th May.
Lordship.
16th.
Obliged.
16.
Then you say, so and so is allowed 2 weeks time, huh? Then this time.
16.
And for the respondent. Only he stuck up in another court. Let it be in another date because.
None
today
addressed
the-
for the petitioner. Mr. U. Goswami, Learned CGC appears for the respondents. List after 2 weeks.
No.
17.
May I please, your lordship? Matter is from dismissal from service, lordship. They have filed their affidavit in opposition. We also filed our reply. Otherwise, it is ready for hearing, lordship.
So it is in the hearing list.
No, lordship. Lordship may take up at a fixed date, lordship, on 14th, lordship.
14th or
14,
16th, lordship, then
16th
16th.
16 lordships.
on request made by the parties. What is the matter on 16th? Huh? Oh. No, he is not getting on. Yes, what do you want?
Lordship, can it be on 22nd, Lordship? Matter item number 8, Lordship.
22nd will not be possible.
Lordship, then
Item 8, what did I say? I don't know what order was closed. On request made by parties. Huh? 30, your senior will not be there.
yes, Lordship.
So when do you want? 22nd will be difficult. We'll have it on 28th.
Lordship, can it be on the month of June, Lordship? First week of June? In
Okay, 4th June.
oblige, Lordship.